1996, praying for appointment of an arbitrator for resolving the disputes between the petitioner and the respondent.
Yes.
Issue notice, returnable 4 weeks, steps on respondent number, sole respondent by registered post AD. Trustee is also permitted.
Right.
List up to the returnable date. In order.
Please, let's see. This is arbitration petition filed under section 11(6)(c).
Will issue notice at this stage?
Yes, yes.
But, counsel. 4 weeks. Steps on the respondents by registered post ID within 1 week from today. List up to the returnable date. Yes.
I'll operate. On the last occasion, inspection
Yes,
was
Lordship, I have sent for waiting, my lord. May I pray for my lord? Immediately after vacation, my lord. I have sent my lord the affidavit, my lord.
After
Immediately after vacation, my lord.
let each date be given then.
Lordship.
Mr. U. Sharma, U. Das,
Yes, my lord.
Current Counsel, Government Advocate, appearing for the department, submits that the affidavit is ready to be filed. However, she, for further weeks' time, submits that the matter be listed after minutes. Counsel appearing for the petitioner submits that the matter be listed on a fixed date. Accordingly, list again after on 28th of April. 28th of April.
Lordship, deeply.
MSR DECA appears for water resources.
Lord, arising out of the same tender work, Lordship, another matter is also pending, Lordship. That matter may also be tagged along with this matter. Arising out of the same tender.
Mention that matter for 28th. The other matter,
Lordship.
you make a mention to be listed on 28th.
Lordship.
Lordship, in this case, Lordship, the petitioners took a loan, Lordship, and took loan, Lordship, and regularly paying their installment, Lordship, but some amount was
You are
due.
challenging the award
Award,
in a writ petition.
Lordship, and they
There
have,
is a provision for appeal. You go and file an appeal, 34.
but with the ex parte, Lordship,
Whatever it may be, go and file an appeal.
then Lordship, I may be allowed to file appropriate petition.
Yes, counsel for the petitioner submits that this petition is filed putting to challenge the award, ex parte award by the arbitrator, 22/1/2025. Whereby the petitioner was directed to pay 15,33,409, including interest and other charges. So, being agreed, the present petition is filed. Thereafter, today when the matter is called up, counsel for the petitioner submits that he be permitted to take necessary steps as prescribed under the Arbitration and Conciliation Act 1996 for assailing the ex parte award dated so and so. In view of such submission, writ petition stands dismissed as not pressed. Petitioner is permitted to take recourse to necessary steps as provided for under the Arbitration and Conciliation Act.
The liberty, Lordship.
Of course,
Of
Oh.
May I please, Your Lordship? The petitioner is paying for direction to the respondent party.
Where is the admission? Completion certificate.
Completion is 15, Your Lordship. Page 15.
Any other documents?
And I have also given them a legal notice, Your Lordship, which was forwarded by the irrigation to the.
What do you say, Mr. Upadhyay?
Lordship, they noticed my Lord, register, Lord.
Why not dispose it of? You verify in,
Lordship,
Lordship notice.
I left.
no, we are asking you,
Lordship, Lordship will dispose of. Do examine the chief engineer will examine the case, Lord.
where is your work order?
Page 11, 12, Your Lordship.
Page 14.
Case 14.
14.
How many works? Only one.
1, Your Lordship.
Third counsel for the parties disposed to non-payment of contractors fee.
6, 7, 10, Lordship similar, Lord.
This is item number
5, Your Lordship.
5, 6, 7,
10.
And 10.
and 10.
All right, Lord.
Oblige.
May it please your lordship.
Yes.
My lord, we are basically agreed by the decision of the authority to engage transport contractor, my lord. In fact, this is a covered matter. Similar matters are pending. So the NIT should be stayed, my lord. If your lordship, just I can indicate, if your lordship would kindly come to page 62.
Yes.
If your lordship would kindly come to 2G. Authorized agency means concerned department of the state government or a body corporate or a company owned by it or a cooperative society. So we are all cooperative society. Then my lord will kindly come to page number 65, 7.1. State government shall lift food grain from the designated depot of the corporation through its authorized agency, not any private contractor. Then my lord will kindly come to page number 66, 8.3. State government shall ensure through authorized agency physical delivery of food grains to the fair price shops by the end of the month preceding the allocation month, in any case not later than first week of the allocation month. So, my lord, could not succeed before the learned single judge, but in writ appeal, my lord, which are pending, interim orders has been passed, based on which, my lord, other orders have also been passed. If your lordship would kindly come to page 144.
Yes.
That's the interim order of the writ appellate bench which is pending, holding the field, having regard to the facts and circumstances of the case, and also considering the fact that the appellants are continuing to lift and distribute food grains from the designated depot. We direct parties to maintain status quo in respect of the existing system of distribution of PDS commodities, insofar as transportation is concerned, till final decision of the appeal. So, my lord, in terms of this, several orders has been passed, my lord. Recently, this order was passed, my lord. ये था उसने, अगला order में आता है. I'll pray for a similar order, my lord.
You are also continuing to lift the
Yes.
items. As on
Presently, we are not doing, our term is over, but they have engaged some other agencies. Transport contractors.
Retapellate court
Huh.
has directed status.
So, Milord, subsequently, the other order which I have given,
Ah.
there also the NIT was stayed, Milord. Milord, going by the Milord purport of the division bench order, the present arrangements should continue.
That's right. That's what we want to.
No, Milord, to be honest, we are not doing it presently.
Ah.
Instead of giving it to us, some other agency has been engaged. But in any case, Milord, if there is a tender, there will be a third party right. At least now we are awaiting the division bench final outcome.
Yes.
Yes, my lord. That is to my lord, at present, my lord, who is my lord, running my lord. That I have no instruction, my lord. Even my lord, in the retable, my lord, it has been stayed, my
Mr.
lord.
K. N. Chaudhary, learned senior counsel, Mr.
M. Setia, my lord.
Setia for
Response number 2
response numbers
2 to 4, my lord.
2 to 4.
I am for response number 1 on behalf of.
I think we
And Mr. S. Thakur
petitioner.
for respondent number
1 minute on behalf of.
1
Respondent.
on behalf of Mr. S. Petitioner is agreed. Petitioner is one cooperative society. How many?
No, all petitioners are all cooperative societies, Milord, different.
16 cooperative societies under in the Tinsukia district. They are agreed by the NIT. Dated issued by the state inviting bids from private contractors for lifting of food grain from designated warehouses of the FCI. Stop. According to the petitioner, NIT itself is violative of the
Order of 2015, Milord. Targeted public
the
distribution.
targeted public distribution system within bracket control order 2015, which was notified on 20 March 2015. It is submitted by the council, senior counsel to the petitioner that the NIT itself is in violation of clause 2G 7 of the said order, and accordingly, there is no scope for the respondent authorities to initiate an NIT for inviting private contractors for lifting the food rates. Counsel for the petitioner submits that the issue pending the court. Writ appellate court in writ appeal number so and so, and status quo order has been granted in this matter. Pursuant thereto, several writ petitions have been filed, and in a similar writ petition, while issuing notice, a coordinate bench has stayed the NIT. Stop. Counsel for respondent, counsel for the petitioner, brings the similar order. Error. Counsel for the respondent submits that they would like to complete their inspections accordingly. While issuing notice, making it returnable after 4 weeks. Let the NIT dated so and so. The NIT dated so and so shall not be acted upon till disposing of the writ appeal. Since the respondent counsels appear, this is the way the extra copies be furnished within a period of 1 week from today. This accordingly.
So matter pertains to outstanding balance liability. Outstanding balance liability.
Balance.
12,42,714. Under PHE. Liabilities page 45 to 47, my lord.
Page
45.
These are in respect of works executed.
Yes, yes. There are altogether 19 works. And they have accepted.
Yes, Mr. Gogoi,
Lordship, let notice the mistake.
heard General Counsel for parties to notice, and number 4 weeks. Mr. R. Gogoi, standing counsel forest,
PH, your Lordship.
PhD appears.
Respond number 1 to 7.
Respondents 1, 2, 3, 4, 5, 6, 7. And who for finance? Anyone for finance?
Finance.
Mr. A. Todia appears for respondent 8 and 9. The respondents are represented by their respective counsels. Notice is a waived except for being furnished in a period of 1 week. Respondents will complete their instructions and may file necessary affidavit if so advised in the meantime. Listening in.
Obliged.
11.
The pendency shall not be a bar.
Tendency shall not be a part. Just
Obliged.
pass necessary orders of the prayers made by the department.
Obliged.
May I please, your lordship? In this case also, lordship, I am praying for lordship. I challenge the e-tender process, lordship. The petitioners are lordship, lifting the essential commodities from the FCI go down, lordship, and thereafter to the fair price shop, lordship. In this regard, lordship, in the year 2015 also, government has initiated a process to take away their
You are
liability.
also relying on the division bench.
Yes, yes, lordship. My division bench, I am also one of the appellant, lordship. My case is also pending, lordship.
Yes,
My lord, because since.
And in this case, lordship, we are now lifting also, lordship.
heard learned counsel for the petition.
more कार होता है more Thailand आया है
Yes,
district
Lordship, status quo, lordship.
whatever order is passed here.
my lord
Status quo order pass. But in this case, lordship, we are lifting, lordship. That case, lordship.
Therefore,
Yes,
status
yes.
quo.
lordship.
status quo it is lifted no
Lordship, 11, 13, 14, and 15 are connected petitions. A tender process was initiated by IOCL, Lordship, for bulk transportation of LPG in the states of Assam, Meghalaya, and Tripura. Lordship, what had happened here is that the primary grievance of the petitioner is that after the bid submission date, a corrigendum was issued, firstly extending the bid submission date, and then by separate corrigendum, parties, bidders who had been earlier eligible, the eligibility criteria and the allocation matrix has been changed to make them ineligible. So if I may take your lordship to the, just through the basic documents, lordship will find the tender notice at page number 23, your lordship.
Yes, yes,
Yes, this is it was in a two-bid system for bulk transportation of LPG by road for the state of Assam, Meghalaya. The technical bid starts at page number 25. Lordship will turn to page 32. There, your lordship, page number 32, trucks, tankers were divided in two categories. We are concerned with the 7 MT and above category here. So 362 tankers were required. Lordship will kindly see the name of the category itself is 7 MT and above. Then at page number 33, your lordship, the trucks, it says that the trucks are to be,
yes,
yes, at page number 33, clause 6, trucks will be inducted as per evaluation stroke allocation criteria as per the table mentioned in chapter 5 with priority to state registered tanker trucks quoted at floor rate. Now, if I may quickly take your, before taking your lordship to the table at chapter 5, the pre-qualification criteria, which is at page number 43.
43.
43. It starts at 43. The table at the bottom that Lordship will turn over to the next page. There is a requirement for having a PESO license. Then at chapter 5, Your Lordship, this is the crux of the dispute. Chapter 5 is the tender evaluation. Chapter 5, page number 63, is the tender evaluation criteria.
Yes.
If Your Lordship turns to, Lordship, if I may draw Your Lordship's attention to clause 6, it says that the allocation will be based on least cost to OMC. OMC is oil marketing company, considering reservation stroke minimum allocation criteria for SC, ST and MSC bidders. So that is the sole criteria. Because if Your Lordship has the table at page number 65, this is a part of the same evaluation criteria. There is no allocation matrix for the 7MT and above category. So the only eligibility criteria, because this table, if Your Lordship has a page number 65, that only pertains to the 21 metric ton and above category. For the 7 metric ton and above category, the only eligibility criteria in the published tender document was that it should be on the basis of least cost to the OMC. Now, before taking Your Lordship to what has happened, if I may draw Your Lordships to the nature in how the dates were changed. There's a chart.
What is the least cost?
Yes, least cost means, Your Lordship, that by giving out the tender to a tanker, the oil marketing company should be able to conduct a transportation of the LPG from one point to another at the least possible cost. Now, what happens here? Suppose there is a tanker of 7 metric ton. So that will, the amount of LPG that a tanker of 7 metric ton can transport, a tanker of 14 metric ton or 12 metric ton can transport almost double that in one single trip. So when a tanker of higher capacity is used, Your Lordship, the cost for the oil marketing company automatically comes down. So that is supposed to be the criteria.
Yeah.
Now, what has happened, if I may draw Your Lordship's attention to the chart at page number 101. This is from their website, from their portal. As per the original tender document, the bids were supposed to start, bid submission date was supposed to start on 20th of March 2025. That Your Lordship will find at page number 102. Now, after the bid submission date had started, on 26/3/2025, a corrigendum is issued. If Your Lordship has the date of the corrigendum at the bottom of the page on 101. Corrigendum number 1, the publication date is 26 March 2025. The bid submission date is postponed from 20th of March to 1st of April.
16.
Yes, I'm reading from page number 101. If Your Lordship has the first corrigendum,
Okay.
at the bottom of the page, corrigendum 1. The publication date is 26 March 2025. So that is after the bid submission date. After the bid submission date, they have issued a corrigendum by which the bid submission date has been postponed to 1st of April.
Hmm.
Now, by itself, that does not.
When was the bid submission date? Otherwise,
Otherwise, it was on 20th of March. That Your Lordship will find at 102, the next page. So after it has started, they have postponed the date. Now, after postponing it, what they have done, this is where the crux of the dispute lies, because we had already prepared ourselves to submit tankers of higher capacity, because that's what the least cost to the OMC would have been. We have invested a significant amount of money. They have issued a corrigendum. The first corrigendum was issued on 28/3/2025, which Your Lordship will find at page number 122. Just 2 days after extending the bid submission date, they have issued a corrigendum. Page number 122.
Yeah.
We are concerned, Your Lordship, with the if Your Lordship turns to page number 125, Your Lordship. Page number 126, I beg your pardon, Your Lordship.
Yes.
It starts at 125, 126. At the bottom of page number 126, there is a separate category called B2, if your lordship has that. At the very bottom of B20, 126 on the right side column, a new evaluation criteria has been added, B2, truck allocation order. I'm reading from
Serial number?
126 on the right column, it's right at the bottom, your lordship.
B2.
B2, truck allocation matrix. Now a truck allocation matrix has been introduced for the 7MT and above category, which was not there in the original tender. This has happened after the bid submission date. Now, what we are aggrieved by, your lordship, is primarily we are very aggrieved. Your lordship has page number 127.
Yes.
Lordship, the portion in bold at the bottom of the page, the number of higher capacity metric ton tankers will be limited to a maximum of 10% of the total NIT requirement, published of equivalent 7 metric ton capacity during initial induction. Proposed tanker trucks offered by bidders other than SUI shall be considered for allocation whenever the requirement is not met by tanker trucks offered in the tender. So what they have said, that tankers of capacity higher than 7 metric tons will be limited to only 10% of the induction of 362, which is the requirement. I have brought up, then your lordship, another corrigendum was issued that your lordship will find at page number 136. The relevant portion is at 137. This was issued on the next day, on 29th. They have said that this 10% cap will not apply to tankers of 8.5 metric tons, because even though that is also more than 7 metric tons, for some reason, best known to them, they have excluded that category. I have produced a chart in this petition, your lordship, that by excluding higher capacity trucks, just in one bottling plant, IOCL over the course of the tender is incurring a loss of 158 crores, your lordship, to themselves. So that definitely least cost principle is violated. And otherwise 12 metric ton trucks, your lordship, are even operating in the hilly areas of Manipur also by IOCL. So there is no difficulty. Yesterday night, after the petition is filed, your lordship, and a third corrigendum is issued. I brought it on record by an additional affidavit. So I have an extra copy, your lordship. This was issued yesterday in the evening. So lordship will see their fluctuating stance. The corrigendum starts at page number 149.
Yes.
If I may draw your lordship's attention to page number 157, your lord.
Yes.
Once again, the 8.5 MT capacity, which was excluded by the second corrigendum, again a ceiling of 15% has been included on the 8.5 capacity. So they are not sure what is happening. Tender conditions are changing multiple times after the bid submission date. So their only, their response.
What is the size of tanker you are submitting?
We are submitting tankers of the capacity of 12.5 and 14.5.
Hmm.
Now, your lordship will notice another very curious thing in this affidavit, because the kind of illegalities that have been perpetuated, if I may draw your lordship's attention to page number 149. Why I showed your lordship the pre-qualification criteria earlier. Page number 149, your lordship will see that even the pre-qualification criteria has now been changed. The requirement for PESO license, there is a change in that requirement. Now, why this is relevant? Otherwise, I am not affected by it, but it will just show the conduct of IOCL. Last year, your lordship, there was another series of writ petitions where certain petitioners who had participated in a similar tender process initiated by IOCL. They had requested for certain relaxations in the pre-qualification criteria. That writ petition was disposed of by this honorable court. The judgment, your lordship, will find at page number 158.
158.
It starts at 158. if I may draw your lordship's attention to the relevant portion at page number 163. Learned Senior Counsel, paragraph number 7, your lordship, at 163. May I read, your lord? Learned Senior Counsel appearing on behalf of the respondents has also submitted on instructions that in view of a circular of the Engineering Department Head Office dated 3/10/2023, if the pre-qualification criteria is changed, then the respondent authorities would have to cancel the entire tender process, which would again cause great difficulty to the respondent authorities in the transportation of LPG cylinders. Now, taking note of their own internal circular, lordship will come to the findings of the court at page number 165. Paragraph number 11. This court has also taken note of the circular dated 3/10/2023, which has been placed by the learned senior counsel appearing on behalf of the respondents, which categorically mandates that the pre-qualification criteria once fixed shall not be relaxed or changed up to the start of the bid submission date. Up to the start of the bid submission date. It is also mentioned that in the specific cases where the pre-qualification criteria needs to be revised subsequent to the start of the bid submission date, the tender shall be cancelled and a fresh tender has to be invited after approval of the revised tender document with the revised PQC. This court, having taken note of the said clause as stated in the circular dated 3/10/2023, is of the opinion that the petitioners have failed to make out a case for the purpose of interference with the pre-qualification criteria as mentioned in clause 14 of the tender schedule, interfering with the said condition or issuing any directions to the respondent authorities to relax the said condition would result in the entire tender process being made redundant, which would eventually result in a fresh tender to be issued, which would further result in delay of the entire tender process and consequently affecting the respondent's business of transportation of the LPG cylinders in question.
But this is pre-qualification.
Exactly, your lordship. So lordship will see the last corrigendum that they have issued. If I may take your lordship to page number 149. Lordship will see the earlier two conditions corrigendum.
What is pre-qualification?
Yes, your lordship. Page number 149 is also a pre-qualification criteria. What they have changed now in the third corrigendum, I am just showing this, your lordship, to see that the amount of illegalities that have been perpetuated, apart from the allocation matrix, which they could not have, they have brought in a cap on the allocation, excluded a category of bidders from the tender process. Apart from that, when their own circular prohibits a change or relaxation in the pre-qualification criteria, by this third corrigendum issued yesterday, even that has been relaxed. At page number 149, chapter 2, pre-qualification criteria, even that is changed. So their actions, your lordship, is completely in the teeth of the judgment laid down in Datta Associates and Media Development Authority. Once a procedure has been announced and people have readied themselves to participate in the
What is the stage of?
bid submission date? Today is the bid. Now the today's bid submission is going to start from today.
It's submitted.
Yes, your lordship.
Yes, Mr. Jordan.
My lord, the last date of bid submission is, my lord, 30th of April. It starts today, but it is up to 30th of April that your lordship will get at, my lord, page 101. If your lordship comes to page 101,
Yeah.
Last but one column, my lord, critical dates. Bid submission start date is 1st of April. Bid submission end date is 30th of April. Now, my lord, I have received some instructions in the meantime. Your lordship will find, my lord, how the petitioners are prejudiced. If your lordship kindly comes to page 105, their case is that they have already purchased 15 number of trucks, depending, my lord, relying on the initial, the NIT. Page 105,
First
they have.
tell us what is the criteria now?
Now, my lord,
What is
this,
the criteria?
now, lord, this, my lord, the memorandum that has been, the corrigendum that has been issued on 6/4/2025, my lord, I do not have instructions on that. My submission will be, my lord, two things. Firstly, my lord, the petitioners are not prejudiced because, my lord, they have purchased 15 trucks And my lord, the number of trucks is much more than, my lord, the numbers they have, my lord, purchased. That is one. And secondly, my lord, if your lordship, my lord, there was a, my lord, pre-bid meeting. And in this pre-bid meeting, my lord, pre-bid meeting, your lordship will find, my lord, it is stated at page, uh, page, the initial, my lord, stage at page 23.
Yes.
Pre-bid meeting, date is 12/3/2025. A pre-bid meeting was held and this issue was not raised. My lord, I have received the instructions. May I, my lord, submit the instructions that I have received? There are 4 tenders, my lord, for Assam and Meghalaya, Tripura, Assam, Meghalaya, and Tripura. 4 petitioners. If your lordship comes to the second page, the reason for capping the number of high-capacity TT trucks and removing 8.5 empty trucks, my lord, this has been given. Now, in the pre-bid meeting, my lord, this was not raised at all. And my lord, after the pre-bid meeting only, my lord, the corrigenda were issued. If your lordship reads, my lord, clause 6, the second page,
Clause 6 of
C, my lord, in the
Clause
second
C.
page of the instructions.
Okay.
The reason for capping number of higher capacity TT trucks and removing 8.5 empty TT trucks for selection. Tender for bulk LPG transportation contract are floated jointly by industry, IOC, BPC, and HPC on regional zonal basis through normal public tender based on common terms, conditions, and rates formulated by the IWC, Industry Working Group of the OMCs. Region-wide pre-bid meetings have been conducted from 6 March to 18 March across India. For Northeast, meeting was conducted on 12/3/2025 at Guwahati, and the meeting was attended by OMC officials and more than 200 existing transporters of IOC, BPC, HPC, and potential bidders willing to participate in the tender. Feedback from the prospective bidder was collected during the meeting on various tender clauses and any other relevant inputs. There was strong representation and opposition from both existing transporters and potential bidders regarding the induction of higher capacity trucks, 12 and 14.1 empty capacity. There was an unanimous plea to cancel the tender and refloat the tender only with the requirement of existing 7 empty capacity trucks only. The major reason being bidders do not have sufficient time to buy new truck and higher capacity tank truck and complete documentation before the tender deadline of 15/4/2025. No contrary plea argument was raised by any of the prospective bidders supporting the tender requirement of the higher capacity trucks. Based on the feedback received, the industry working group thoroughly deliberated on the concerns raised during the pre-bid meeting and the matter was subsequently reviewed at the higher management level. Before arriving at a decision, details of 12 empty, 14 empty capacity vehicles holding valid PESO license and registered in Assam and northeastern states were verified with the PESO. It was found that only 12 new vehicles had been granted PESO license on 19th and 20th March 2025. Considering this, it was decided to impose a cap on the induction of high-capacity trucks in the tender process to ensure that all available vehicles get a fair opportunity of participating and can suitably be accommodated. Now, my lord, my submission is my lord, twofold before your lordship. Firstly, my lord, there is a representation by the petitioner, and my lord, last date is 30th of April. Your lordship may direct the IOC to, my lord, dispose of the representation of the speaking order within a limited time, my lord. That may be fixed by your lordship. Alternatively, my lord, I'll file my affidavit. my lord, contesting their claim.
Yes.
Let them
Because
file
my
their
lord, the time is still there, my lord, up to 30th of April. Before that, your lordship may decide the entire issue.
Firstly, your lordship, this issue of capping could not have arisen in the pre-bid meeting because it was issued after the pre-bid meeting. The corrigendum of 28.3, where the capping was introduced for the first time, that was introduced after the pre-bid meeting.
So see, whether it is 7 MT or 12 MT or 14 MT, the decision to be taken by the IBC.
Absolutely, absolutely. I cannot have any quarrel with that.
So therefore,
But once the bidding process has started, because the lordship will see that 20th of
bidding process starts from which day?
it was supposed to start on 20th March 2023, 2025. On 26th, that is after the start of the bidding process, they have issued a corrigendum trying to extend the bid submission date. So on
Now
20th,
it has already been extended. You are not challenging that.
no, I am not challenging that, your lordship. They can very well do that. What I am aggrieved by, your lordship, is that after the game has commenced, they are in effect challenging the rules of changing the rules of the game.
You are participating there.
No, why I am prejudiced.
It's not a case that you did not participate.
No, I can, even if I participate, your lordship, how I am prejudiced by the change in the rules of the game.
Your prejudice is because you have purchased those
Originally,
higher
everybody was supposed to be treated equally. 7MT and above, if you are 7MT or above, you are going to be treated equally. By issuing this allocation criteria, they have limited the number of trucks for allocation that are available to us to only 10% of the total allocation. While the 90%, the rest of the people can. They have changed the rules of the game. We are second class participants in the tender
What
process.
do you say regarding the pre-bid meeting?
In the pre-bid meeting, your lordship, there was no discussion regarding this. The corrigendum of 28.3, which for the first time introduced the cap, that was introduced after the pre-bid meeting and after the bid submission date. Has
So if your representation is there,
lordship.
let them dispose of the representation, looking into your grievances instead of keeping the matter pending here.
Lordship, lordship may give them the liberty to decide the representation, but I know, your lordship, even after the representation, we have
Right,
been.
you do one thing. We'll permit you to file your counter here, but pendency of the writ petition will not be a bar for disposing the representing also. If the authorities feel that it can be looked into, grievances can be ameliorated, do it.
My lord, I'll agree to that, but then your lordship will see, my lord, ultimately the conditions of tender, those are being challenged here.
We'll examine that.
I am not challenging the conditions of tender. I am challenging that how
And
after the
because,
bid
my lord, the
submission
rules of
date.
the game have not been changed, rules, my lord, the game starts from
We'll
today.
examine that.
My lord.
We'll examine that.
Lordship, then till then, your lordship, let them not finalize the tender process, because if they do
So,
that,
when is the last date?
the last date is on the 30th.
So before 30th, nothing can be finalized.
Then your lordship may at least consider my interim prayer on the next day after they
Yes,
file the response.
yes.
Very well. Your lord.
Third, learned counsel for the parties issue notice returnable on 23rd April.
Right.
The petitioner is agreed by the change in the tender condition by the respondent authority in the NIT which has been issued dated 1/3/2025, inviting bids for award of contract for transportation of bulk LPG by road for the states of Assam and Meghalaya for a period of 5 years. Is the submission of the counsel for the petition by referring to various documents enclosed to the writ petition that the tender conditions have been altered after the bid process had been initiated, which according to the writ petition is contrary to the law. Laid down by the apex court as well as this court in Ekate now decisions rendered stop. It is submitted that the criteria for reduction of higher metric ton tankers has been done to benefit certain persons who are participants in the NIT, and such action of the respondent authorities, according to the petitioner, will entail a loss of
To the IOCL, a cost of 158 crores.
158 crores. Stop. This being a public enterprise, such decision causing loss to public finance cannot be permitted without any basis. Stop. He therefore submits that the tender process, the authorities be restrained from proceeding further in the tender and finalizing the bids received in the meantime. Para. Counsel appearing for the respondent strongly objects to the submissions made by the petitioner. He refers to instructions received to submit that there was a pre-bid meeting held, and pursuant to such pre-bid meeting held, it was decided that the higher capacity vehicles would be permitted to an extent of 10% of the of what?
10% of the total acquired, total number of vehicles to be acquired.
Total number of vehicles to be acquired / required for the transportation of LPG. Stop. He therefore submits that there is no infirmity or violation of the tender clause. Stop. He further submits that the tender submission has started from
today, my lord,
from 7th of April
up to my lord 30th of
and
April.
will continue up to 30th of April. Therefore, there is no question of change of the terms and conditions of the NIT during the bid process. Stop. He further submits that a representation has been filed by the petitioner, dated so and so, which the respondents may be permitted to be
29/3/2025.
page number
138.
138.
38.
Representation dated 29/3/2025 is pending before the authority, and the same may be permitted to be disposed of by the respondent authority. Then, we heard counsel for the parties. This court is of the view that at this stage, notice be issued permitting the respondents to complete their instructions and file necessary affidavit in the matter. The interim prayer will also be considered on the next returnable date. Further, the respondents are also permitted to look into the grievances raised by the writ petitioner by way of their representation and pass necessary orders in the meantime, if so advised. Since the respondents are represented by their respective counsels, notices are waived. Extra copies be furnished within a period of within the course of this week. Within the course of this week. Matter be listed again on 23rd of April, and the respondents may file their counter affidavits in the meantime. if so advised. Prayer for interim, notice on the interim prayer, returnable on 23rd.
My lord, just for clarification, your lordship has directed to dispose the representation or given liberty to dispose the representation.
Given liberty.
Obliged.
Item numbers 13, 14, and 15.
Similar.
13 is by another petitioner. Everything else is same. The tender is for Tripura.
Item 11,
11, 12 is something, some other matter. 13 is for Tripura,
13, 14 and 15.
15.
11 is for which state?
11 is for this matter was for Assam and Meghalaya.
Sub Meghalaya.
13 was for Tripura.
13 Tripura,
14 is again Assam, Meghalaya.
Assam, Meghalaya.
And 15 is for Tripura.
Dates of representation same.
Sorry?
Dates of representations are same.
Yes.
All right.
Obliged.
But here I am challenging the rejection of my bid, technical bid. What will turn to the petitioner here, my lord. Petitioner here is a startup. And here that participate in the bidding process, my lord, which was held on, which the lords will find to page number 26 with the bid of the GEM. It was uploaded on 10/2/2020, right at the top, my lord. And the last date was 4/3/2015. 25 is the date of filing, last date of filing the bid, my lord. And this is regarding the interior of a, this is now 27, my lord. If you will find in the BQI title, my lord, interior furnishing of a Toswakhana circuit house. And the total amount is like 126 lakhs. It is 1.26 crore. And the petitioner has furnished its bid, my lord. What you will find in page number 88. It is a bunch of bids, my lord, involving all.
Page number?
Page number 88.
88.
88. There are 28 papers are given, my lord. 21 papers are given, my lord, consisting of 47 pages, my lord. All the documents were annexed, including, my lord, not in 19, my lord. This is a startup registration and everything has been given, my lord. Thereafter, my lord, bid was bid, and in the meantime, my lord, actual bid in the bid was there was supposed to be a pre-bid meeting on, as per the NIT, on 10/2/2025. Lords will turn to page number 213, my lord. Pre-bid meeting was actually, as per the NIT, it was supposed to be held in 10/2/2025, but the pre-bid meeting was suddenly announced on 18/2/2025 on page number 213, my lord. Suddenly it has been announced on the portal, my lord, on 18/2/2000, lawful fixing at 12 p.m. on the same day. Then the objection was raised by the petitioner that the opportunity was not given to the person who are local, who are outside that particular district, my lord. In the next page, my lord, page number 214. Thereafter, my lord, thereafter, my lord, the bid were opened. And total participants are 10 participants, my lord. And he is one of the participants, my lord. He is page number 216, my lord. This is the type copy of that. It has been disqualified. That petitioner has been disqualified on 19/3/2025. Lords, you will see in the status, it is type copy is disqualified, my lord. Reason is that no single work completion certificate submitted amounting to 1.26 crore.
Yes.
Immediately, my lord, on the online itself, the representation was given. Lords, you will find it in page number 218.
200?
218. These are all online, my lord. I have already typed it, that particular portion, my lord. That showing that there is a clause in the NIT, in the GEM portal, my lord, in the NIT, my lord. This clause 5 itself says that if your OEM has that particular technique, that qualification, you need not have to, the petitioner doesn't have to show it, my lord. And lordship will now turn to that particular clause in page number 29, my lord. Regarding past performance, page number 29, serial number 5. That portion that have been quoted in the page number 5, 26, page number past performance, my lord. the bidder or the OEM themselves or otherwise reseller should have a supplied same or the similar category of product for 80% of the bid
You're
quantity.
reading from which?
Page
bracket?
29, Lord.
Page 29,
29 down below in the serial number 5, my lord.
serial number 5.
That is the qualification of the past performance.
Yes.
Bidder or its OEM should have supplied same or similar category of product for 80% of the bid in the last one of the last 3 financial year before the bid is opened, date of central state organization and PSU. Means that 80%, that 128 amount, 126 lakhs is 1.2, he said at least 80% of the last 3 amount. Lordship will turn to now the OEM certificate, my lord. Lordship will start, it starts from straightway. Lordship can turn to page number 147. OEM certificate starts in the portal from 139, my lord. 140 is the page it starts giving all the OEM certificate, my lord. Now Lordship will turn to page number 147, my lord. This is the turnover of the OEM, my lord. Even the profit of the OEM is more than the amount, my lord. Lordship will see 2023, 24, 20, and from 2019 to 2024, my lord. OEM's amount is huge amount. Even the profit is more than the total amount that is the bid amount. That is the fixed by the.
This document was not submitted.
These documents are submitted online. They are not taking it, my lord. They say you don't have it, not the OEM. The clause is something else, and they say that you are not qualified as a bidder. Now, after that, my lord, Lordship will see, my lord, come to page number 220, my lord. How they have disqualified not only me, there were 10 participants, my lord. In the technical bid itself, all the 9 were disqualified, my lord. Page 220, my lord.
Page
220, my lord. Only my number is 8, petition number is 8. Disqualified.
Yeah.
8, serial number disqualified. Lordship will see there are 10 participants. All the 9 were disqualified in the technical bid, my lord. Only one, serial number 2, that is the private respondent, he has been made qualified. And thereafter, after that representation, in the next place itself, 221, he said, this is financial bids are open, you are qualified. That is that amount has been given, that you are qualified. And thereafter, my lord, representation was given on 26/3, my lord. And they have not considered. If Lordship, there is another clause, my lord, regarding startup. If Lordship turns to page number 24, for a startup, these clauses are, first of all, my lord, the OEM is qualified, turnover has been given. In page number 24, 5, since this the petitioner is a startup, in rule number 173 I, my lord, of a GRF, this is the GRF rule, my lord, GFR rules, my lord. Rule 173(1) of the GFR rules exempts the startup from prior experience and prior turnover requirement in the so-and-so startup objecting meeting the qualification technical, subject to meeting of qualification technical specification and making suitable provision for the bidder document. If the turnover and startup doesn't require the pure activity and turnover, another clause that a petitioner is protected, being a startup. First of all, the turnover has not been taken over. This provision also has not been taken over, and then their tender has been disqualified.
Yes.
Lordship, can you come to page 217, the disqualification communication, Lordship. 217, Lordship, it is inform about the disqualified. Down below, Lordship, the representation of the petitioner, Lordship. May I read, Lordship? With due respect, we are sorry to say that we understand within bracket missed the clause number 5 in the bid document saying the bidder or its OEM should have supplied same or similar category products for 80% bid quantity. We now uploading the relevant documents for the above mentioned clause. Please find the attachment. This is for your kind information.
This is submitted by whom?
This is
by the petitioner, Lordship. They have already admitted, Lordship.
Yes. Lordship will see. the
Because
second
Lordship,
next
that disqualification of the technical bid was, it was uploaded on 19/3, and this was this representation was made on 26
Yes, yes.
3/25. That means, and by this representation, Lordship, they have admitted that they have underseen Lordship.
No, no, no. That's Lordship will see the next page, my lord. I have given it in type copy, my lord. There are two provisions, my lord. First of all, in the top, it is the information that no single work has been done. Then after that, the communication, my communication, this is what my friend is reading is my communication. That is not type copy, my lord. That there is a clause 5 in page number 218. Clause 5, there is a provision that if OEM qualifies, then also it is the turnover is complete, my lord. And OEM's turnover is huge amount, my lord. Even the profit of the OEM is more than the amount, my lord. Because that's why, my lord, next page I am giving it
But
type
you,
copy.
you have to submit that information.
That's because that information has been,
How will the authority find out what is the turnover of the OEM?
no, OEM has already been submitted. That's why, my lord, that's why this clause, my lord. Lord, he will turn to page number 139. 139 onwards. The entire branch has been in the portal, submitted in the portal. They have overlooked the page number 147. 140 itself, my lord, entire branch had to be OEM's qualification had to be uploaded in the portal, my lord. Among them is the page number 147. That had been overlooked, my lord. First of all, the qualification of the turnover of the OEM. That's why the petitioner is referring to the clause 5 and reloading it at clause 5 and other things, my lord. That's OEM have to be, you have to upload it. You cannot escape from that, my lord. These are all online process, my lord.
Okay, what is the status now?
Status, my lord, my information is that no work order has been issued till date, my lord.
Will be
My lord,
subject to
this-
the outcome of the writ petition, what interim orders you
Oh,
want.
my lord, if the work starts, my lord, the disqualification is arbitrary, my lord. These
We'll
papers
have
should
to
be,
examine that.
my lord, in the interim, my lord, that work should not start, my lord. My lord, what?
You
What are
will
you-
have to show that you have been wrongly rejected. There is a shortcoming on.
Yes,
your
that's
part
why I am showing the page number 147. 147 is the turn of the OE.
Right, heard Mr. S.
My lord, in the interim, it will be protected, my lord.
By appearing. Respondent authorities petition. Petitioner is put to challenge the
Tender regulation committee.
rejection of the petitioner's bids, which was submitted in e-tender dated 10/2/2025, bearing numbers issued through GEM under General Administrative Department for a total of 1243 items for installation and interior furnishing works at Wakana Circuit House, fixing 4/3/2025 as the last date of submission to bids. The tender is for all 1243 items.
Yes, 1 crore. This is the interior of a circuit house.
One tender.
One tender. 1, 2, 4, 3 items.
Counsel for the petitioner submits. Petitioner is a startup within quotes. And in terms of the bid condition, the turnover of the original equipment manufactured within bracket OEM and obligor of the supplier, namely the bidder, is one of the particulars to be submitted along with the bid document. Stop. It is the submission of the counsel to the petitioner that the turnover of the OEM was duly submitted, which was sufficient to satisfy the conditions of the contract bid document. Stop. The authorities, however, overlooked the said document and rejected the bid of the petitioner Where is the rejection order?
Page
Page
207.
120, no, this 128, my lord, the type copy, and the rejection order is on 219.
Rejection order is
219, my lord.
217.
Second. 218 is the type copy, my lord. Down below it is tentative, it is rejected. And original is the 219. After the representation is given, immediately they reject it. My lord.
no. First you are rejected.
No, first
No,
you are
first
disqualified.
Disqualified.
Where
Then
is
the
Where is
representation,
that disqualification order?
disqualification order, lord,
217, Lordship.
217, right at the top, my lord. No single work completed, completion
The
certificate
petitioner
submitted.
stood disqualified on the ground that within quotes, no single work completion certificate submitted amounting to rupees 1.26 crores. So the counsel for the petitioner submits that the rejection could, in respect of the writ petitioner, could not have been issued in view of the required documents showing the turnover of the OEM, which had already been furnished to the concerned authority. So nevertheless, petitioner thereafter submitted his representation through the online portal, which also came to be rejected. Stop. The further contention of the writ petitioner is that the, how many persons are there? Bidders
Total 10,
submits that out of the total 10 bidders,
9 were disqualified.
9 were disqualified and only the private respondent number 5 stood qualified. Stop. It is submitted that since the petitioner is startup, the benefits prescribed under the tender condition are available to the petitioner, which however was not considered by the respondent authority, then thereby wrongly rejected the claim, the bid of the petitioner. Being aggrieved, the present writ petition is filed. Where counsel for the respondent submits that the reason for rejection of the bids of the petitioner is reflected in the web portal, whereby the bid was rejected as no single work completion certificate was submitted. Stop. He further submit that this deficiency was sought to be cured by the petitioner subsequently by representing before the authority, where it was admitted that they had missed the clause number 5 in the bid document, and the relevant documents are being uploaded. Stop. Since these bid documents sought to be uploaded by the petitioner was after the contract evaluation period, the representation stood rejected. He submits that there is no infirmity in the rejection of the writ petitioner as he could not satisfy the criteria specified. Having heard counsel for the parties, he issue notice and return about 4 weeks. The respondents will file their necessary affidavit in the meantime. Steps on the private respondent by, have you taken steps on the private respondent?
No, this is the motion, my lord.
Motion what? But you are asking for an interim order against the shortlisted candidate.
The interim order, I am actually asking whether that lordship will consider it, my lord, because
I am for
all the
respondent number
documents are
2, 3 and
uploaded.
4.
All the
I am
documents,
for 2 and 3, 2, 3 and 4.
because all the documents are uploaded. Only thing is that they have not gone through it. Oversighted.
You should notice on the interim. Petition has gone 28th of April.
My lord, if the interim is not given, my lord, that then the work will start. My lord.
You should have served him a copy.
My lord,
You're asking for an interim order ex
before,
parte.
at the time of before the motion, I cannot serve it copy, my lord. If there is no caveat, my lord, I cannot serve it, my lord. That's the difficulty, my lord. That's why, my lord,
28th
everything has been uploaded. Section clause 5 has been
It will be
violated by the
subject to
respondent
outcome.
itself.
It will be subject to outcome. What else?
My lord, if the work starts, my lord,
Work
then
starts, it will be subject to
my
outcome.
lord, it will be infructuous, my lord. That's why, my lord. Because at the same time, I have also said that the amount that financial bill has not been open. My financial bill have been open. I would have been L1 because the amount given, I am not disclosing it. The amount given is much lower than the respondent, private respondent.
All right. Matter be listed again on 28th of April to reconsider the prayer for stay of the writ petitioner. However, it is made clear that the petitioner must ensure service of copy on the private respondent within bracket shortlisted uh, bidder and file an affidavit of compliance thereto. Stop. List on 28th till the next date fixed. Work order is issued to the petitioner to the respondent number 5 shall remain state.
Problem. I will take dusty look. Dusty.
Whatever you want to take.
I am for
But
respondent number
ensure
2,
that
3 and
copies are
4.
served. Mr. S. Burua for 2, 3 and
SR
4.
Borua for 2, 3 and 4.
3 and 4.
1
For
GAD, GAD department. GAD department. A or not A Fukan name.
Mr. A. Kugan for or what?
Right. Yeah, my okay. Problem.
May I please your lordship? Lordship, this writ petition is against the order of the Superintendent of Food and Civil Supplies cancelling the license of the petitioner who was running a fair price shop, lordship, since 2006. Although there was no complaint from his consumers regarding his service, his license was cancelled on 24/2/21, lordship. And then we filed application before ADC on 16/3/21. I'm submitting before your lordship an order of this Honorable High Court in a similar matter, lordship.
Yes.
Lordship, this matter may also be disposed of in a similar way, lordship.
You have filed an appeal.
Yes, lordship.
Where is
Lordship,
that
they find it on page 16 of this petition. Application, lord.
Have you seen this order?
No, my lord. In fact, my lord, she filed this application against my lord suspension order. It is already cancelled, my lord. As per my lord, APD order, my lord, against the cancellation, she may file an appeal, my lord, under order 29, my lord. There are some public distribution article order, my lord.
It has been cancelled now.
Yes, my lord.
Yes, lord.
Then what remains? Your
Yes,
petition has become infructuous.
Yes, lordship.
Then you file a fresh petition.
Yes, my case appeal, my lord, against the
Fresh
cancellation.
appeal as per the
You file it.
protocol.
Third learned counsel for the parties. The writ petition is directed against the suspension of the
Now it is against cancellation order, my lord, page 17, my lord.
The suspension of the license number 2636 of the Fair Price Shop under the Udharpon Cooperative Society Limited. So, being aggrieved, the writ petition was filed. An appeal before the Additional Deputy Commissioner, Food and Civil Supplies, was also filed, which the petitioner claims was pending. So, subsequently, the pursuant to the inquiry conducted, the license issued to the petitioner stood cancelled as per provisions of APDA Order 1982, Clause 15 within bracket 1. So, aggrieved, the petitioner is before this court. Para. The counsel for the respondent submits that there is a provision for an appeal before the competent authority, and the petitioner may approach the appropriate authority for filing an appeal against the cancellation undertaken issued by the respondent authority. So, counsel for the petitioner does not dispute the contention raised. Accordingly, the petition stands closed, permitting the petitioner to approach the appellate authority, namely the Deputy Commissioner,
Deputy Commissioner,
Kachar,
District Commissioner now.
District Commissioner Kachar,
Yes, ma'am.
for filing a necessary appeal against the cancellation of the license of the writ petition. So, the respondent authority will thereafter proceed to decide the appeal, if filed as permitted within a period of 60 days from the date of receipt of a certified copy of this order, and pass a speaking order thereof. Any order that is passed, copies thereof shall be served on the petitioner. Yes.
All right.
What will allow me 2 weeks time to file my affidavit, my lord, after view vacation, my lord.
My lord, it has been pending for last 2 years, my lord. My lord, this is for release of admitted amount, my lord.
Running bill, my lord.
Admitted amount, my lord.
For supply,
Contractual work, my lord, section of road, my lord. Your lordship,
you examine and release it.
My lord,
lordship, I have to
because
see.
this is a running bill, otherwise I have not objected. This is a running bill, my lord. Lordship will post it on 28, my lord, 28 or 30, my lord, April, my lord. I will get the entire instruction, my lord.
Annexure 10, my lord, page 65 may kindly be seen, my lord. There is no dispute in respect of this amount. I am only claiming this much money. My bill amount is much more higher. But my lord, in this petition, I am claiming only this much of money.
It has already been sanctioned.
Section, my lord, they are not paying.
Release this
No
amount.
sanction.
Yes. You examine and
Lordship,
pass necessary orders in terms of the sanction order.
sanction, my lord.
The heard learned counsel for the parties, this writ petition is directed against the non-release of an amount of rupees
30 lakhs, sir.
30 lakhs, which was sanctioned by the PTC Kokrajhar by the order dated 24th of March 2021. The petitioner was awarded the work within quotes. Construction of interlocking contract block pavement in the road from Orjun Bormont House, Rukohi Irrigation Canal at Rajapin, page number 65. So this work was duly completed, was executed. Is there a completion certificate?
No,
My lord, completion certificate up to the extent of 56%.
This is a running bill, my lord.
The work was undertaken by the commissioner, and about 56%.
56%.
Of the work has been completed, for which running bills have been raised. So the PTC authorities, by the order dated 24th of March 2021, had sanctioned the amount of rupees 30 lakhs for the said work. So it is the grievance of the petitioner that the notwithstanding the sanction. But the sanction must have lapsed by now.
My lord, this fund has been suffered to come under profit, my lord, without releasing the same.
No, the sanction which is granted on 24th of March
My lord,
21
my lord.
will lapse by 1st of April 22, 21. The fresh sanction will have to be granted.
My lord. This other direction, my lord, annexure 11, page 66, my lord.
The
This is also 21, my lord.
the
Requisition was given, my lord, by the Director of Panchayat and Rural Development to the Secretary.
the counsel for the petitioner submits that the sanction, although granted, has not been, the amounts have not been released. So counsel for the respondent submits that he would like to complete his instructions in the matter. So the counsel for the petitioner, the other end submit that the matter is pending since the last 2 years. And he prays for an order that the respondent authority be directed to examine the claim of the petitioner, and if found payable, then the amount which was sanctioned should be released. Counsel for the respondent does not object to the prayer made. Accordingly, the petition stands closed. Directing the respondent number.
No, respondent number not 2, my lord.
Respondent number,
2.
my paying authority, respondent number 5, my lord. Respondent number 5. True, my lord. Respondent number 2.
No, respondent number not 2, my lord. Respondent number 3 is the principal secretary. It will be true principal secretary. 3.
But paying authority is respondent number 5, my lord.
The respondents, more
Respondents will
particularly
be with us.
respondents number 2, 3, and 5, to examine the claims of the writ petitioner, and if the amount which was sanctioned by order dated so and so is found to be payable, then necessary orders be issued for releasing the said amount payable to the petition. So, in view of the order passed above, the writ petition stands closed. The entire exercise we carried out within a period of 90 days from the date of receipt of a certificate copy of this order.
Much.
Lordship, in this matter, I'm requesting for further 4 weeks time, my lord. I have already filed my affidavit, my lord.
Yes.
Actually, my lord, what happened, my lord, the draft rules is about to finalize, my lord, by approved by the cabinet, my lord, about to approve, my lord.
My lord, order is of 7/3/2024. And there was a direction, my lord, to take the action for running the private market of the private respondent, my lord. The operative portion at page 15, my lord. Page 15, my lord.
Yes.
Para 11, my lord. Accordingly, this court is of the view that unless and until the respondent number 8 gets the approval for running the private cattle market under section 107 of the 1994 Act from the government, the petitioner would be ineligible to run the market. However, keeping in view the fact that the respondent number 8 has been running the private market for a long time, some time should be provided to the respondent number 8 to seek approval for running the market. Accordingly, the respondent number 8 shall submit an application seeking approval of the government for running the Bagbor private market under section 107 of the Act on or before 12/3/2024, addressed to the principal secretary to the government of Assam PNRD department, who shall take a decision on the respondent numbers 8 application within a period of 3 weeks from the date of receipt of the report. So the principal secretary has to take a decision on the application, because without the approval of the government,
Nobody can run a private market, my lord.
Yes. Next paragraph also,
And
my
more
lord.
particularly cattle market, my lord.
Uh,
As MS Yudas Learned Counsel for the response numbers 1, 2, 3, and 7 has stated that the application of the response number 8 to run the cattle market has been forwarded by the District Commissioner Borpeta to the Secretary to the Government of Assam Home and Political Department on 23/8/2023. The said authorities should decide the application within a period of 3 weeks from today. Till a decision is taken by the authorities concerned with regard to the application submitted to be submitted, the private market being run by the response number 8 should not be disturbed. However, the above is subject to the condition that the response number 8 submit his application to the Principal Secretary to the Government of Assam PNRD Department for seeking approval under Section 107 of the Act on or before 12/5/2000.
My
So
lord,
apparently, my lord, that application representation have been submitted, but no decision has been taken, my lord, by the authority till then.
my lord, the petition was filed by the petitioner against the response number 8, my lord. Thereafter, my lord, the honorable court, my lord, passed this order that response number 8 will apply for the NOC, my lord, and government will consider that. Read petitioner, my lord, and they
You are
does
still
not
running
have
it. Who's running it?
private respondent, my lord, not the petitioner. There is not at all
Private respondent is running a cattle
legal
market,
grievance
my
of the
lord,
petitioner is there,
without
my
the government approval. The requirement
Yes,
is
ma'am.
that for running a cattle market, my lord, approval from the government is necessary, my lord.
After this order, my lord, the private respondent applied for the NOC, my lord. What happened, my lord, the act is amended in the year 2023, my lord. But the rules are yet to be finalized, my lord. That is why, that was indicated, my lord. In my affidavit, I have mentioned it, my lord. To the petitioner as well as the respondent number 8, my lord. It was intimated, my lord, that the rules are being framed, my lord. Thereafter, we will consider as per rule, my lord. And
No, but by your inaction,
my lord.
the respondent 8 is continuing to run the market without approval. How can you allow that?
My lord, yes, my lord. Lordship
How can you
may,
allow that?
once again, paragraph 12, I am reading, my lord.
So you read para 11 first.
Yes, yes. After 107, my lord, as the rules are not amended yet, my lord, that is why government is.
Rules may not be amended. Whatever existing rules are there, you take your decision.
Yes, my lord.
Your inaction has allowed somebody to run the market without approval.
My lord, yes, my lord, that market.
There is a clear direction
You are
by the
violating the order.
Lordship may fix the matter immediately after vacation, my lord. We will pass one any order, my lord, of complying this court's order, my lord. At this stage, like a provisional order, we can pass order, my lord, but as the rules are not framed, my lord, that is where.
If you want clarification, file a clarification.
My lord,
Application seeking clarification.
My lord, I understand.
But once an order is passed, you are required to carry it. Para 12, it has been sent to District Commissioner.
District Commissioner part is already over, my lord.
Already over.
Yes.
It has been sent to the Secretary.
Yes, my lord.
Home and
The
Politics.
government. That part is
who
not
to
with.
take a decision?
My lord, there are two parts, my lord.
Hmm.
One part is the DC part, my lord. DC will give the license and NOC from the government. Government means in PNRD department.
government in the PNRD department, principal secretary.
You take your decision.
Yes, yes, my lord.
Heard counsel for the parties. The directions contained in the order says 7/3/2024, passed in WPC 6634 of 2023. Required the Principal Secretary to the Government of Assam PNRD to take a decision on the application filed by the respondent number 8 within bracket in the writ petition, bracket close, within a period of 3 weeks from the date of receipt the representation. Stop. Whereas this decision has not yet been taken by the respondent authorities. Being agreed, the contempt petition has been filed. Counsel appearing on behalf of respondent number
1 and 5, man.
1 and 5. Prays for further time to comply with the directions contained in the order. Purely for the ends of justice. Matter stands deferred to be listed again on 28th of April, well, by which date the respondent counsel will apprise the court of the compliance with the directions contained in the order dated so and so, passed in WPC so and so by the respondents. List again on 28th.
Highly obliged.
Obliged, my lord.
Lordship, can this matter be taken up on Friday, Lordship? Because some order has been passed, but the sole respondent, Lordship, he is in Calcutta for some medical treatments, Lordship. So can it come on Friday, Lordship? I'll get,
The request made by counsel for the health.
yes, Lordship.
This is a contempt.
Yes, ma'am.
Mr. D. Upamanyu appearing for the respondent, matter stands deferred to be listed again on Friday, if the date. Mr. S.S. Brahman appears for the reference.
Highly obliged.
Happily. Possibly self-citizen has been filed, my lord. For non-compliance of order dated 15 to 24, my lord.
Where is that order?
My lord, page 11. From annexure 1, page 11 of contempt.
Yes.
On 16 to 24, my lord. Heard Mr. Adel, Learned Counsel for the petitioner, and also heard Mr. B. Gogoi, Learned Counsel for the petitioner. Petitioner's grievance is not payment of his contextual dues after execution of his contract work amounting to rupees 21 lakh 75,376 in connection with contractual work so for the year 2001-2002. Petitioner had earlier approached this court by filing WPC, which was disposed of by the order dated directing the respondent to deal with the grievance of the petitioner in accordance with the full bench judgment of this court in case correspondent. But that was not complied with, my lord. Then the petitioner had again approached this court by filing the subsequent petition. Mr. B.V. Gogoi, Learned Counsel for PWRD, submits that Parawai's comments have given by the executive engineer, Territorial Road Division, Dibrugarh, which has been sent to the chief engineer, has been communicated to him in terms of Parawai's comment, which has been forwarded by the chief executive engineer, PWRD, to the chief engineer, PWD Road, by letter dated 15 to 24. The genuineness of the claim of the petitioner was verified on the basis of available papers in the office. The name of the petitioner was not found in the original chronological list available in the office for payment of his outstanding liabilities, and the said finding was communicated, my lord.
My lord, may kindly peruse page number 21 of our affidavit, my lord. After receiving the court order, my lord, chief engineer directed the additional chief engineer to inquire the matter properly, my lord. After inquiry, he has submitted this report, my lord. Page number 22 is the report, my lord.
22.
22 is the report.
22 is the
21 is the additional shifts to chief engineer, my lord. In our affidavit, my lord. Page number 21 is additional chief to chief engineer, my lord. And 22 is the report. Number 22, my lord.
which paragraph?
My lord, documents available as per office record. These 10 important documents are not available in our office, my lord. It's a matter of 2002, before 23 years, they have allotted the work, my lord. These documents are not available in original. So if they can submit the original,
Which documents?
my lord, the tender notice,
They don't have
approved
to take the
estimate.
notice, my lord.
Important things is, my lord, administrative approval, formal work order, technical sanction. This is not available, my lord. If they can submit this one, we can release, my lord.
These are inter-office communications. How I can hold this document, my lord? These are their inter-office
My lord,
communications.
work was allotted in 2002.
No, but there is an order of the court. If there's, or if you think that this order cannot be complied with, then you have to file a review against that order.
Mm.
There is an order of the court. You go to the order of the court.
The lordship, I cannot see phase 12 of order, my lord. Para 6, my lord, phase 12. Of contempt petition, my lord.
See the order of the court.
Phase 12, my lord, or 6.
There are some communications referred to on the basis of which the court is of the view that the claim is genuine.
Genuine, my lord.
Before the inquiry, my lord. It was passed into 16 to 2024, and an inquiry was done in.
No, inquiry was done, but what do you say about the observation of the court in para 6 of the writ petition? There are some letters which are referred to, 15 to.
I have to check, my lord. It is not available with me. I have to check,
You check up and find out.
my lord.
Because the prima facie view of the court is that the claim of the petitioner is genuine. So if it is genuine, then you comply with the order.
This order has not been challenged, my lord.
Check, my lord.
And if you think that it is not genuine, or it cannot be verified whether it is genuine or not, you have to take steps.
Mm.
List again after 2 weeks.
That's not a view, my lord. If possible.
2 weeks, matter be listed, enabling the respondent to apprise the court as to the status of the compliance of the directions contained in the order dated so and so, passed in WPG so and so. List according.
63 also. 20.
Similar, my lord. Similar.
Which one?
Next one. 21.
21.
Deeply obliged.
Much.
Please, John. In this matter, service is complete on respondent number 7 in both the writ petition.
Right.
That was pending. That has been completed.
Who is respondent 7?
Respondent number 7 is the IRP in the matter here. Shri Kuldeep Verma.
Liquidator, my lord,
Liquidator.
I am appearing.
For the IRP.
Liquidator.
In item number 22, I am filing wakalat number. In 23, I have already filed wakalat number.
All right. Then notice is issued.
And to all, time was granted to the other respondents to file their replies. Respondent number 2 and 3 have stated that they will not be filing replies. The other respondents may then comply. I have the respondent number 4 in item number 22, Lord.
Pursuant to notice being issued, counsels represent all the respondents. Since the service is complete, matter be listed for admission.
Only one prayer, my lord. The petitioner will be directed to serve one copy.
The counsel for petitioner will ensure service of
Very good.
Both
copies
the
on all the
writ
respondents in respect of both the matters. List in the month of May.
Please,
Deeply.
Deeply.
Thank you, Lord. Next question.
May please, your lord. Lord, herein, in this case, I have filed an application earlier to vacate the interim order. In case, in the present case, this is a settlement of a fishery, my lord. In the tender process, I am the highest valid bidder. You know, the petitioner participated the tender without submitting the earnest money.
Yes.
But whether an invalid tenderer can approach this honorable court for any judicial relief.
No. What was the grievance of the petitioner?
Petitioner gives I am a defaulter, but I am not a defaulter. That also in this case admitted by the court.
The tender was issued to you.
Tender settlement was issued to me. And the petitioner selling, now the petitioner has to prove his own credential, my lord, because I raised an objection as to that he has not deposited the earnest money.
Then we'll take up both the matters together then.
My lord,
Writ
it
petition
can be
along with the
disposed of,
I-
my lord, early date, my lord. I only pay.
Yes.
Records. Last occasion, as per, they are made by both the parties, Malat, the honorable court directed to produce the record, Malat, records are with me.
In Ronak,
Oh.
in the case of Ronak, my lord, one line is very important. My lord, any judicial relief at the instance of a party who does not fulfill the requisite criteria seems to be missing. Your lordship can, I need an early disposal. ma'am.
You have not been able to operate the fishery.
No, so settlement was given prior to approach this honorable court. But because of this High Court pendency of this case, they are not formally hand over.
What is your objection here? What is the ground for vacating the interim order?
Vacating order, the order was passed after the issuance of settlement order.
That's right.
First thing. Secondly, my lord, the writ petitioner has not deposited his earnest money along with the tender. A tenderer cannot participate, a tender cannot be accepted.
You are representing which respondent?
I am responding 4.
Hmm?
6, my lord.
6. In the writ petition, have you filed your counter?
No, I have not filed an counter because my application for vacating will be maybe treated as a counter. That will again delete the matter, my lord. The record is here, record very well.
And what is your response to the allegation that you did not submit the
You can see,
what amount?
They stated at objection in para 10.
Earnest money. You did not deposit the earnest money.
According to them, there is no such provision itself in the tender. By filing an affidavit, they on wait, oath, paragraph 10, my lord. Paragraph 10 of the objection, my lord. Has your lordship got it?
Yes.
That the statement made in paragraph 7, paragraph 7, I allege it. Deponent begs to the tender that the demand did not contemplate the deposit of earnest money, which will be evident from annexure 2, page 20 of the thing. If your lordship take up the writ petition, my lord,
Yes.
read at page tender, start from 21, tender form. Twenty-two page, has your lordship got it?
Yes.
7, the tenderer should enclose the following document. No. Proof regarding 15% deposit of first year's reserve price along with the date and bank. Has your lordship got it?
Yes.
They have not deposited it. It is an admitted position.
Yes, government, what do you say?
My lord, this is the my lord tender condition. In this case, my lord, we have received the instructions.
You said you have the record.
Yes, my lord, since
Go
last.
through the records and tell us. Go through and tell us whether this is deposited or not.
My lord, this is the voluminous record today. I have.
This is your record.
I have received today morning. my
If
lord.
you're scared by the size of your record, then only you have to.
I'll have to go through my lord.
Can I have it up?
You you don't try to scare the court by the size of the record.
Today morning I have received now, my lord.
Say that.
I'll have to go through the
Go
record,
through it and we'll fix up the matter. Tell us when.
my lord, that.
On reopening, my lord. I'll be out.
Reopening.
My lord. On the.
I was thinking at 2 p.m.
Yes, my lord, regarding my lord, whether,
You have to tell us from the
Mal-
records whether the petitioner is otherwise qualified, has submitted all documents as required.
my,
Petitioner has been disqualified,
yes, my lord.
not disqualified.
Mal-
The private respondent has been settled as the highest bidder.
Yes, yes,
That tender on record is still available.
my lord.
They have said no.
Okay.
Or
Yes.
Thursday, my lord.
Thursday. I'm out of station next week.
Out of-
Mhm. On reopening day, my lord.
All right. Reopening day,
21st.
22nd. 22nd
Yes.
April.
My lord.
List this matter again on 22nd of April,
That's fine.
enabling for admission.
Yeah.
For admission hearing,
My lord.
the IA will also be taken up along with the writ petition. The counsel appearing for you are for the fishery department.
Government.
Well, I am for the deputy commissioner and other circle officer.
This record pertains to what?
Tender, my lord.
Tender, my lord,
Deputy
because
is a 40%.
40% fishery, government fishery.
Okay. The counsel, MSU Das, government advocate, appearing, representing the deputy commissioner, will produce the relevant records before the court, perusal if the needs to arise. At least accordingly. Yes, you are appearing, Mr. Your name, Archetri, on behalf of P. Sharma, appears for the fishery department. List according.
Same order in 27 also.
27, similar order.
For 24. I'm the one.
25 and 27.
25 and 27, both are same.
My lord, I have received the instructions, my lord, affidavit today, my lord. I am going to file the affidavit.
In item 27,
My lord.
you write government council has is submits that the affidavit prepared on behalf of the department shall be filed within the course of the week.
Pass over for timing, Lordship.
Timing.
Timing, Lordship. The senior standing counsel on late, Lordship. After some time.
All right, timing.
Item 28 is an IA for implementing the new incumbents as respondent number 2.
Any objections?
Yeah.
IA 971. Heard counsel for the parties. The petitioner, the applicant submits that the who are you seeking implement?
Implement a custody manner.
Submits that
IAS
Sri so and
Principal
so
Secretary.
Akash Deep, IAS Principal Secretary, Boroland Territorial Council. He is presently the concerned officer who is required to comply with the directions contained in the order dated so and so, passed in WPC so and so. The same not having been complied with, counsel for the petitioner submits that the opposite party is required to be arrayed as the party respondent. Where MS so and so appears for
I am borrow from Mr. P. Naik, Your Lordship.
Mr. P. Nayak appearing for the respondent number 1.
Yes.
Stop considering the prayer made is IAS stands allowed. The petitioner is permitted to array the Akash Deep IAS Principal Secretary Boroland Territorial Council as of respondent number 2 in contempt case number so and so. Amended first title be filed within a period of 1 week from today. I stands disposed of in terms of the above. In the contempt petition, to write in view of the IA, view of the order dated so and so, passed in IA so and so. The Akash Deep so and so is arrayed as party respondent number 2. Issue notice on the newly implemented respondent number 2 steps by registered post AD along with usual course be undertaken within a period of 2 weeks from today. That will be listed there.
Item number 30 also same. Same
30.
respondent, same respondent.
30.
Item 30.
Akash Deep.
Akash Deep, yes.
Same. Date of the order and the petition is different.
Deeply obeyed.
My lord, this IA for my lord implementing the party respondent.
Yes.
My lord, page 4, my lord, lordship will find the prayer portion, my lord.
Page 4.
Page 4
Ah.
of the IA.
Paragraph.
My lord, prayer portion, my lord.
Prayer portion.
Prayer portion.
There, what is the direction in the writ petition?
Direction, my lord, lordship will find in a contempt at page, my lord, 48. Operative part, my lord. Page 54. Paragraph 5, my lord.
direction is to the circle officer.
Circle officer. Now, since circle officer matter has not referred to the deputy commissioner,
Hmm.
the deputy commissioner has not given the approval, and as such the matter is pending. Now, circle officers repeatedly saying that once the approval is given by the deputy commissioner, he can carry out the exercise, my lord. That is why, my lord, the deputy commissioner also need to be implemented.
Has the circle officer said it? On what basis are you
Now,
making the statement?
when the petitioner approached the circle officer,
Anything in writing?
there is no writing.
Have you stated in your IA? Paragraph? In anywhere in the IA? Nothing here.
My lord, there are two, my lord, middle portion, my lord. The applicant has already communicated the order dated so and so, passed into so and so to the incumbent, that is respondent number 2, 3, 4 respectively. But those incumbent has not taken any step to comply the order dated so and so, passed by the Honorable High Court, and as such the newly incumbent 2, 3, and 4 to be implemented as party respondent number 2, 3, and 4 respectively. There are two, my lord.
There are two.
Yeah.
Now, where is that statement that you are making a statement that due to inadvertence?
Yes.
But the direction is not against the.
Yes, that part is not there. That
then you'll have to bring it on.
But the circle officer, my lord,
Circle officer will impede.
yes.
No problem.
Now, earlier circle officer has not been
Who
transferred,
is the
my lord.
circle officer? Who's
News.
the newly implemented? Who's the
Right.
person who's
Krishna
required to be
Kant,
newly implemented?
Krishna Kant Sahari.
Krishna Kant
Sahari.
Sahari. So we'll implement only the circle officer.
Well,
IA number so and so. This IA has been filed seeking implement of the following respondent 1, 2, 3, 4 as no. Who is the circle officer now?
present circle officer, my lord, Nilaksi Butso. Yes. Earlier has been transferred.
She has been transferred.
Yes. Krishna Kanta Sahari has been transferred. Now, Nilaksi Butso.
Now who is to be implemented?
The Nilaksi Butso.
Seeking implement of number 2, 3, and 4, huh? Not 1. Stop. Counsel for the petitioner submits that the directions contained in the order dated so and so, passed in WPT so and so, was not carried out. And meanwhile, the incumbent was holding the post of, was serving as circle officer, Ojai Revenue Circle, was transferred. And therefore, the new incumbent is required to be arrayed as party. After perusal of the order dated so and so, passed in WPT so and so, it is seen that the direction of the coordinate bench is again is to the circle officer to look into the grievances and pass necessary orders. So, according to the writ petition / applicant, the deputy commissioner and the additional deputy commissioner of Ojai district are required to be implemented as parties in view of the fact that the order directed to be passed by the circle officer would not be passed in view of sanction not being granted by the deputy commissioner and additional deputy commissioner. Stop. However, no such averment is found in the IA that has been filed. Stop. Under such circumstances, since the direction of the court by the order dated so and so passed in WPC so and so is specific to the circle officer. This court is of the view that taking into consideration the submissions made by the counsel for the party that the present incumbent holding the post of circle officer Hojai Revenue Circle is required to be included as a party respondent. The I stands allowed to that extent. So accordingly, Srimati Nilakhi Bushra, ACS Circle Officer, Hojai Revenue Circle, Hojai, he is permitted to be, he is directed to be included as party respondent number 2 in contempt case number 377 of 2023. The prayer for implement of respondent 3 and 4 at this stage is declined in the absence of specific averments made seeking the necessity of including the said respondents 3 and 4 as a party respondent. Stop. I accordingly stands allowed to the extent indicated above and disposed of. The petitioner will file amended course title before the registry within a period of 2 weeks from today. Whereas, in view of in the contempt petition, right, in view of the order passed in I so and so, Sri so and so, Srimati so and so is the as party respondent. But 2, petitioner is directed to file amended course title within 2 weeks from today. So, Para let notice issue on respondent number 2 of the newly implemented respondent number 2, returnable by 4 weeks. Steps on the said respondent by registered post usual course within 2 weeks from today.
Developers.
List accordingly.
Okay, I am praying for lordship improvement of opposite party number 4 and 5 in the contempt petition lordship.
Who are they?
Lordship, respondent number 4, lordship, he is the nodal officer in the Department of Lordship, Assam Skill Development Initiative Society, and respondent number 2 is the director. The earlier director has in the meanwhile lordship being posted in another.
Four or five.
4 and 5.
You are referring to page number?
Page number lordship 4.
4.
4 and 5.
Then you are seeking improvement
of opposite party number 4 and 5.
4 and 5. Any objection?
I also sent prior notice.
Let the notice go, madam. It is a contempt, madam.
Already I have.
We'll implement it.
Yes.
We'll implement
Yes,
them
sir.
and then issue notice.
Yes, sir.
Right, I'll learn counsel for the party. As I stands, I been filed seeking implement of opposite parties number 4 and 5 as party respondent with contempt petition number so and so. So it is submitted that the directions contained in the order dated so and so, or it passed in WPC so and so, has not yet been complied with. So, counsel for the petitioner submits that were the parties before the court? Before
Yes.
before the writ
Yes,
court?
yes.
Nothing.
Yeah, okay. Okay.
By the earlier order, dated so and so passed it. Not earlier order, order passed by the court and bench in WPC so and so. The order dated so and so. directions were issued to the director. Employment and Craftsmen Training and Members like the Assam Skill Development Initiative Society Assam to carry out the directions contained in the said order. So, counsel for the petitioner submits that notwithstanding the directions contained, the same had not been carried out by the respondent authority, requiring the petitioner to approach this court by filing a contempt petition. Stop. The contempt petition, the director, Srimati so-and-so, was arrayed as director. She has demitted office.
He has been now posted as lordship, different posting lordship.
She is no longer holding the charge of director.
Director.
She is demitted office as the director, employment and craftsman training, and in her place, Sri Anant Lal Gyani has been appointed as the director. The IA is therefore filed seeking implement of the new incumbent in the post of the director, as well as the principal secretary, skill, employment and empowerment department as respondents 4 and 5 in contempt petition number so and so. Parent. Counsel representing the respondents 1, 2, and 3 appear before this court. Parent. Considering the submissions made and taking note of the directions contained in the order dated so and so, passed in WPP so and so, the IA stands allowed. The Sri so and so are arrayed as directed to be arrayed as party respondents 4 and 5 in contempt case number so and so. Petitioner will file amended post title within a period of 2 weeks from today. Para. In the contempt petition, you write in view of ISL's disposed of, in view of the order passed in IA number so and so. Sri so and so are arrayed as party respondents number 4 and 5. Stop. Petitioner will file amended post title before the registry. Stop. Since the newly impleted respondents are arrayed as party respondents, let notice issue, returnable 4 weeks. Steps on the newly impleted respondent by registered post ID along with usual courts list after the returnable date.
Okay, may I submit, my lord? But may I submit? But the principal secretary, but he was not a party in the report, my lord.
Let him file objection. None appears for the petitioner on call. None represent the petitioner on earlier dates. It is 22/1/2025, 28/3/2025, 3/4/2025. It appears that the petitioner is not desirous of pursuing the contempt proceedings before the court. Accordingly, the contempt proceeding stands closed. Notices issued are recorded. This point. I think I should put it. Yes.
Please. Sir, we filed this application, my lord, seeking some extension of time to comply with the order passed by the Honorable Court Lordship. Okay, we are right in order dated Lordship 2011-2024, a direction was issued to the my lord Federal Board of Direct Taxes to consider the representation filed by the petitioner. Accordingly, Lordship, time limit has also been prescribed, my lord, from 60 days from the date of receipt of the certified copy. However, Lordship, Due to some, my lord, departmental, my lord, communication issues, my lord, it was reached to the office of the, my lord, board, my lord, on a subsequent date, my lord. Therefore, my lord, we are filing this application, taking further 12 weeks, my lord, to pass appropriate order, because, my lord, notice has to be issued to the petitioner also, my lord, by granting them an opportunity to represent his case.
Yes. This IA has been filed by the Income Tax Department seeking enlargement of time for disposal for passing necessary orders in terms of the directions contained in the order dated 2011-2024 passed in WPC
3009 oblique
3009 of
24.
By the said order, a direction was issued to the CPTT authorities to consider the claim of the petitioner for condonation of delay on the grounds of hardship and thereafter pass appropriate orders. The entire exercise was directed to be carried out within the outer limit of 60 days. So, the counsel for the petitioner has referred to the grounds urged in the present IA seeking enlargement of time. It is submitted that because of official process required to be undertaken, the directions could not be carried out within the time specified in the order dated. So, the matter is now before the CPTT, and considering that a proper hearing is to be undertaken and notices are to be issued to the SSC, the prayer is made on behalf of the department, praying for further time of 90 days.
Lordship.
60 days maybe.
Okay. Do it within 60 days.
Lordship.
So, council appearing for the SSC does not object to the prayer for enlargement of time. However, he submits that prayer made for 90 days may not be enlarged. So, considering the submissions made and also taking into consideration the grounds urged in the IA seeking extension or enlargement of time, this court is of the view that ends of justice will be met if a further period of 60 days is granted to the authorities concerned to carry out the directions contained in the order dated so and so, passed in WPC so and so. IA accordingly stands disposed of. The directions can be carried out within 60 days
From today, Lord.
from today.
Deeply.
Lord.
It would priority di Marigibra from today. Yes.
My lord, may I please to pass over this matter for time being, my lord. Conducting counsel, Mr. B. Gogo is occupied in court number 5, my lord.
Time being.
Lordship, instruction not received. After Bihu,
Yeah, these are the, my lord, admitted bills, my lord.
Hmm?
All bills are admitted bills, my lord. Part of the bill has been kept in withheld. I have completed the work.
Where is your work order?
My lord, my work order is start from this PMJY work, my lord. Annex 1 itself is there.
Page number?
Annex 2, my lord, this page 37. Page 37. This is the letter of acceptance. This construction of PMD as I wrote, my lord. I have completed the works. This page 100 is the completion certificate. And some bills have been kept in withheld, my lord. Page 100.
How soon can you get your instructions here? How long?
After Bihu, my lord.
So after you give us a date. Give us a date.
My lord, in first week of May.
Better be listed on 30th of April, by which time the respondents will complete their instructions in the matter. 30th,
My lord, let it be 28, my lord.
28th already, 28th of April. Apply still voting.
Lordship, we have paid the amount, we have received the instruction. I think. Right.
What is your claim?
Ship our final bill
What
was
is
not
the
paid.
amount? What is the
Amount
amount?
is 61 lakh. 61 lakh 35,186.
That has been paid. Has been paid.
Lordship. If it has been paid, then the matter become input. But I don't have instructions. If that is there, it's okay.
When the client has received money in, therefore no instruction. Heard learned counsel for the parties. The claim of the writ petitioner is to an amount of rupees 61,35,186, which the petitioner claims remain pending for the works undertaking. Remain pending and not released, although the petitioner completed the works allotted to him. Stop. Para to the, when the matter is called up, counsel appearing for the Director of Women and Child Development Assam has placed before a court a communication dated 5/4/2025, wherein it is clearly provided that where it is clearly mentioned that final bill amount of rupees 61,35,186 has been paid to the petitioner by the bill number so and so dated 2003/2024. As received from executive engineer so and so, it was filed. In view of that position as placed before the court, the grievance of the writ petitioner has been the claim of the petitioner has been resolved by the department and no further cause is alive in the present writ petition. Accordingly, the same stand closed as not pressed.
Next.
MS so and so appears for petitioner, Mr. Borua for
For respondent number 1, 2, and 3.
1, 2, and 3, MSM Das for PWD.
Obliged.
Obliged.
May I please as a lordship? My lord, same instruction is awaited. My lord, in fact, the entire amount is admitted only one, my lord, letter I beg to draw my lordship attention. Last page, page 49. Only due to insufficiency of fund, amount could not be paid, my lord. My lord, they will make necessary arrangement and can pay, my lord.
Yes.
Can be disposed of, my lord, in accordance with law.
Samserali.
Samserali, my lord.
Right, heard. Done counsel for parties disposed from Serali.
Obliged.
Yes.
May I please, Your Honor? I'm appealing for the respondent number 2, Industrial Cooperative Bank. The draft affidavit in opposition has been sent to respondent number 2 for signature, but that is not received back yet. Therefore, I'm seeking for the 2 weeks time to file our affidavit.
That is a matter will be fixed after 4 weeks. I'm out of session.
Counsel for the, what bank? Which bank?
Industrial Cooperative Bank, respondent number 2.
Respondent 2, Industrial Cooperative Bank submits that the affidavit can be filed within a period of 2 weeks as steps are being taken to finalize the affidavit. Counsel appearing for the petitioner submits the matter be listed after 4 weeks, by which time the affidavit can be filed and stop. Prayer made by the respective counsel is allowed. Matter be listed after 4 weeks, by which time the bank will file the affidavit and the petitioner can also file the reply affidavit if so advised at the reply. Mr. S. Chakraborty for?
SK Chakraborty
SK
for respondent number
Chakraborty
3,
for?
my lord.
For? No, Mr. Chakraborty for?
Respondent number 3, my lord, Provident Fund.
3. Mr. Goswami for?
1.
1. After 4 weeks.
Obliging.
It's a covered issue, my lord. I will place the order, my lord. In fact, your lordship has also passed an order, my lord, directing the petitioners in a similar case to approach the, my lord, appellate authority. Yes, I will place it, my lord. Just after some time, I will place it. Day after, my lord. What the council, my lord?
Pharmacy council. Place the order, which he says covers the same issue. Wednesday.
Wednesday.
There is some similar order, he says.
Yes, sir.
We'll have it on Wednesday. Do you have a copy of that order?
No, my lord.
Let it come on Wednesday.
Lordship, Wednesday.
Lordship, perhaps there is no live issue pending, your lordship, because the EMD money has been withdrawn, your lordship, by the petitioner.
Lordship.
Yes,
Yes, your lordship.
it is submitted by the council appearing to the that
1, 2, 3, your lordship.
respondents part 3 that the EMD money deposited by the petitioner has already been withdrawn. So accordingly, he submits that there is no live issue to be urged in present proceeding. Where counsel for the petitioner does not dispute the submission made by the respondent on the basis of the instruction. Accordingly, the petition stands dismissed as not pressed.
Much obliged, sir. Much obliged.
May I please, lordship. Lordship, notice of motion was issued, lordship.
My lord, it's a non-payment of contractual bill, my lord. My lord can dispose it of at a time frame, my lord.
Where is your work order?
Work order, lordship, from page number 15 to 22. 1515, lordship.
Where is it admitted? Is it admitted?
Not admitted.
But work have
There are
completed.
several works.
Several works, my lord.
Yes, yes, lord.
How many works?
There are total 8, lordship. And work has been completed as per verbal instruction of the higher authority. Petitioner have completed his work, lordship. Here in the work orders, it is stated.
No, the completion of it to work the allotment.
Now work done as per verbal instruction. He's done his work.
Lordship will fix this after vacation, my lord. So I'm trying to get some instructions. Because normally courts fix my lord a time frame when we are again faced with contempt.
These are all works by the same petition.
Yes,
My lord.
one person, same petition, my lord.
You get the instructions here.
Well,
Get the instruction.
Yes, lordship. Date may be fixed, lordship.
It will be listed again on 30.
Unless-
By which time the respondent will obtain the required instruction.
How does my lord?
unless-
Keep it delivered.
In these matters, my lord, I am seeking 6 weeks further time to complete the instruction. Regarding supply, non-payment of amount bill against supply of relief materials. That is being examined at the moment by the department. Revenue Department.
Yes. Counsel for the respondents pray for further 6 weeks time to complete the instruction. Software made is not objected to by the council. Matter be listed again after 6 weeks. Of like.
I'm awaiting instruction, my lord.
Yes.
Date may be fixed then after the Bihu vacation.
Counsel for the respondent, that is Udas. Review the prayer for further time.
First week of May, my lord.
This is what non-payment.
Non-payment. Higher charges, vehicles of the petitioner were taken by the department.
Why not dispose it of?
My lord, because the amount, my lord, amount has to be verified by the department, my lord.
Last week of April.
The date may be. By which date? The respondent will complete their.
My lord.
This on 30 April.
30th.
PM.
Yeah, if it had been filed, my lord. On behalf of BTC, my lord.
Well, the conducting counsel is misoperating another court. Lordship may pass out for the timing.
It is helpful. It has been.
You want to file a reply?
No, my lord, we'll do the case with him.
Then lordship will fix a date, my lord.
Lordship is on.
Time being.
Time being, my lord.
Any updates?
My lord, we have been skipping through all the judgments which have been rendered by Honorable Apex Court as well as the High Courts. My lord, almost all the judgments are under the new scheme. Your lordship, lordship knows that there was a new scheme brought in with effect from 1/4/2021 by the Finance Act 2020. Now, as per the new scheme, first they have to issue a notice for inquiry, then the SSC has to submit its reply, then they have to file, pass an order, and only thereafter, notice under section 148 can be issued, not before that. Earlier, it was not so. Earlier, if there was a reason to believe before the assessing officer on the basis of material those are available, then he could have issued the notice under section 148. Now, in our case is under the old scheme. Now, we have challenged the validity of the notice itself as these did not meet the requirement of section 147. So that is the case, my lord. On that day, my lord has mentioned that your lordship has indicated that there may be some case which may not support our case, my lord. We have not come across any such case, my lord. If My lord, if your lordship can indicate any of such cases, then my lord, we may be directed to file our written submission on such case.
Then we are closing it for here, for order. We'll close it for orders.
My lord, if there is any case, as your lordship has indicated, have indicated,
I I'd have to, I'd have to now, if I find something contrary, we do something.
your lordship will refix the case again.
Otherwise, it is, you have already heard.
Otherwise, we have completed our arguments.
I recollect submitting that there is subsequent to the matter being heard. There were several judgments being passed on the across different high courts, including the effect. In that context, I was saying that perhaps not all of them will support your case.
Yes,
There
my
will
lord.
be a slight change in the trend.
My lord, we had come across one judgment of this Honorable High Court in the case of Abhishek Mittal versus Union of India. Now, in that case, it was held, my lord, that in that case, the writ was not maintainable. It was held. But there, the facts of the case were entirely different. The law was entirely different. There, the assessee himself has admitted that he has taken accommodation entries. And there, what was under challenge was the order under section 148 AD passed by the assessing officer under the new scheme. Mind.
All right.
My lord, if your lordship so direct, we can file a detailed written submission on this particular case.
You already filed.
No, on this particular case, this Abhishek Mittal, which I have mentioned. This is not applicable at all, my lord.
It's all right. It's up to you. It's up to you. All right. All right.
Mine.
We reserve it. Written argument.
55 and 56, can I be taken up after some time? I'm led by Mr. Kane Chaudhary. He's on legs.
That on Wednesday. Wednesday.
Wednesday.
It's again. Wednesday. 55 and 56.
56 both.
Both. Wednesday.
Yes, my lord, I have placed it in the record.
Pursuant to the order dated 13/3/2025 passed by this court. Justice P.K. Chari, former judge of the High Court, was appointed as a prospective arbitrator, sole arbitrator. To resolve the disputes arising by and subject to a written declaration as required under Section 12(1) of the Arbitration and Conciliation, 1996. Para. It said written declaration has been placed before the court today by the petitioner. So, the learned uh, 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 Justice P.K. Mochari has issued a written declaration that there is no disqualification for him to act as the sole arbitrator. Decide of the disputes arising by and between the petitioner and the respondent. In that view of the matter, P.K. Mochari, Justice P.K. Mochari, retired, he is appointed as the sole arbitrator. Decide on the disputes arising by and between the petitioner. Respect of the work, art, work cutting, and construction of minor bridges, retaining wall, pakka approach road, alignment, and other ancillary work between chain in to in between station Mualkhang in Saireng in connection with construction of new broad gauge line from Wairabi to Saireng, Mizoram. Para 4 per side port. Order dated 13/3/25, para 4. The parties are therefore directed to appear before the learned arbitrator.
After Bihul also.
After you give a date?
No. How do you go April also?
That means
On
21, 21st of April,
on 25th also.
21st, 25th will be there, yes.
25th.
Some-
25th.
I'll not be there, my lord. So can
Then
it be
26
21st
also
or
also,
2nd?
26 no.
21 or 22nd?
26.
Because he is on holiday, he has not much.
22nd.
22nd, yes, my lord. 22nd.
22nd?
Yes.
I have no objection.
Because I don't think he
22nd
will
of
be there, yes.
And thereafter, the learned arbitrator will proceed to site to will proceed to act as the sole arbitrator as per the order taken.
No petition jumbo ase lamba mo.
Arbitration petition response of the arbitration.
Dos.
Obliged.
This is
We have filed affidavit, my lord.
regarding non-payment of bill of the vehicle mail. This is hired by the Assam Police mail. Now my claim is mail 22,20,447. In para 3 of the affidavit mail, it says mail I claim less mail.
22,39,877, my lord, calculated by the department, my lord.
And according to you,
According to me, 22,20,447 mail.
Lordship,
they want to give you more.
Yes, madam.
my lord, yes, they have calculated, my lord, the department has calculated, my lord. Lordship will find page 38, paragraph 3, my lord.
So this is admitted amount.
Yes, yes, yes.
Pay that amount. Third counsel to the party. Petitioner has put his court seeking a direction for release of his pending bill for what supply of vehicles?
Yes, madam.
Hiring of vehicles.
Yes, madam. Maruti Omni, madam.
According to the substantial amount is outstanding and the same has not been reached. Whereas the respondents have filed an affidavit where at para 3 there is an averment that the total amount payable to the petitioner is shown to be 39,877. So the custom to the petitioner submits that this is the amount receivable by the petitioner in respect of the vehicles. Where I view of the This is the government that an amount of 39,877 is shown to be outstanding and able to the commission. This court, therefore, this court the petition, the direction to ensure that the amount shown to be payable to the repetition is released within a period of 60 days.
4 months, man.
60 days from the date of receipt of a certified copy. Repetition is both of the front of the. Yes.
59.
Here also we have filed the affidavit, madam.
In pair 3 minutes, I claim excess minute.
Yes,
Oh,
madam. Here to get.
Pair 3 minutes, I have claim an excess amount of 3,724 minutes. But against the minute, their admitted amount were flag 97,757 minutes.
Paragraph 3 last paragraph, Lordship will find the breakup, man.
They've already paid 9,06,075 rupees. Now remaining is 3,91,682.
82.
Same or original, but only thing right is that how things raised with the petitioner amount of 9,06,075 has already been paid, and balance amount of rupees 3,91,682 is shown to be outstanding payable by the respondent. Accordingly, since the department has already admitted its said amount required to be paid, the petition stands disposed of, directing the respondents to release.
Respondent number 3.
Respondent number 3 is the said amount within a period of 60 days from the date of the certified copy.
Make with your lordships. My lords, I have instruction to appear on behalf of respondent numbers 2, 3, and 4, my lords. Although I have not filed my Vakalatnama, which will be filed within a week, my lords. And I would like to file affidavit in opposition, my lords. So kindly 4 weeks time may be granted, my lords.
None appears to the around for Mr.
T. Das.
T.
Das.
Das. Also, be in court. So perhaps you'd like to file an affidavit and accordingly praise for 4 weeks time. Mr. T. Das for
respondent number 1, your lord.
appears to respondent number 1. Accordingly, matter be listed after 4 weeks.
Deeply obliged.
Proceed with the court personnel. So I may be permitted to file one additional affidavit in the matter. So we have already filed one affidavit, but thing is that I have seen, but the facts are there, but also the issue of the matter is not been reflected in the affidavit in the person also. So maybe Lordship, I may file one additional affidavit.
Otherwise, but question is that after pending this repetition, and we are giving the extension of monthly basis. They can file affidavit for final hearing. They can fix for lordship final hearing, but in the meantime, my present extension may not be disturbed because from the December onward, I have annexed all extension. Month to month extension is given to me.
I am only interested in the government service has to be done. He does or somebody else does. I'm not concerned with it.
No, you are.
I am Lordship.
Appearing on whose behalf?
I'm appearing on this affidavit of person has been filed on behalf of respondent number 4. Lordship. Basically, I'm paying on behalf of all the respondents.
How soon can you file your additional affidavit?
3 weeks, Lordship, because the Perez comments are with me.
We'll have it after the vacation.
I'm the extension already, they have given the month-to-month extension. Only my prayer is that they let the file the application and fix it for a particular date for hearing. And in the meantime, this extension, the process of this extension, if it is discontinued, then I will suffer. That is the only my prayer. Only till the disposal of that, I find that because the parent, then I may be this present system.
Was any interim order granted earlier? Was there any interim order?
No intermediate is passed. But we are challenging.
How we can.
Here we are challenging speaking order, in which I was my PR was rejected. That is for extension of my period of rejected. And thereafter, after continuing with this petition, they even expire my original period of terms. They have from December onward, they have every month they have extended me my service because it is a supply of medicine. And therefore, if they said even opening of the days, vacation or whatever, lordship will find that otherwise, even now I am continuing. Even
That's all right, but there is no interim order. While issuing notice,
yes,
no interim order appears to have been prayed for or was granted.
Yeah.
So now, if you want any interim order, then ordinarily you have to file an application.
Yes, nothing.
So therefore, we can fix it on 22nd. And you
In
file
fact-
your additional affidavit on that.
In fact, I can assure you until 22nd, nothing will happen. Status quo will be there.
Status quo, and then lordship will find it everything status quo.
I will communicate with that purpose.
Till date.
Learned counsel for the parties, Mr. C.K.S. Burwa. Learned counsel appearing for CGC. Submits that he'd like to file an additional affidavit. Mr. Burwa expresses his apprehension that his present extension may be discontinued by the respondent. Stop. Mr. C.K.S. Burwa, learned CGC on the other end, submits that till the next date fixed. Submits that the expression expressed by Mr. The counsel for the petitioner is misplaced, as till the next date fixed, there shall be no the present status quo will be maintained. Okay. In view of the submissions made by the council, let the matter be listed on 22nd of April. And since an undertaking is given by the learned counsel for the council appearing for the central government, status will be maintained. The next date fixed on 22nd.
Right. Possible.
April.
But please, your lordship. Lordship will file a rejoinder today itself. So let it come up in the record, your lordship.
So for the petitioner, and therefore be listed after. Before I guess for
Transport department.
transport. After 2 weeks.
Obliged.
Deeply obliged, your lordship.
May I please your lordship, my lord? Here in the instant. Okay, say, sir. Here in the instant case, my lord, what happened, my lord? Earlier, my lord, the petitioner was released on interim bail, my lord. And on the basis of interim bail, there is a direction to appear before the learned court below, my lord. Because charge sheet has already been filed. We are appear before the learned court below, my lord. And my lord, I file an additional affidavit, my lord. As per my lord, that additional affidavit, my lord, after my appearance, I was released on regular bail on 8/8/2023, my lord. That was my lord in additional affidavit page 133, my lord.
And my lord,
33.
yes, sir, 133 of additional affidavit. Now, I will also got it. It was filed on 11/9/2023.
Yeah.
That is the order, my lord. Now, my
Which
lord,
page number?
page number, my lord, 133, my lord. That is the order, 8/8/2023, my lord. Seen the petition number so and so filed by the Lalbor Ali, praying for to comply the order that passed by Iman. Honorable Court in AB, the petitioner has submitted one copy of the order that passed by this Honorable Court. It appeared the Honorable Court allowed the petitioner Albert to be released on PRS bail in connection with this financing bail on Iman. And the following condition, it is further that in a file that condition has been mentioned, what your lordship has given condition. Next, after condition, it is further directed that in the event of petitioner is found to be violated any condition to be involved in any other offense, the interim bail granted to the petitioner shall be recalled. There is no, my lord, case against me, my lord, and the other condition has been mentioned, my lord. The Honorable Guwahati High Court has further called for scanned copies of the entire case record, including the updated
Yes.
status.
What has happened now?
Now I am regularly appearing, my lord. Trial is going on, my lord. One of the, my lord, accused, my lord, was declared as a, he has not appeared. Due to that, my lord, appearance is going on.
Yes.
Still in the stage of appearance. And fact is that there are in the charge sheet 36 numbers of witnesses. And one thing is that, yes, along with others, this petitioner was also shown as absconder. But regarding the main culprit who has attacked, there are few, though several persons are there in the mob, but there are few persons who has actually done the blow with Torwal and all this, that he bhala.
The petitioner.
Among those, name of the petitioner is not there. But otherwise, the person was killed, and
He's
maybe
already
that
on interim bail.
only not in regular, but he has appeared on as per the interim bail.
Is there any contention that he has violated any of the conditions in the bail?
So he has, he has appeared as per the interim order and before the court below. Trial is going on.
As per record by law, each and every day I appear.
The second time application matter. Initially, first time rejected for petition of the procedural matter, particular petition rejected matter. If the petitioner matter is reflective on the earlier order matter. Now, this is the second time application.
Where is the earlier order?
On the earlier bail order matter.
Page Annexer 3, page 28.
That page I have check mark regarding the main culprits and all this. And
The charge sheet.
in the charge sheet. That is annex also.
Earlier, my lord, order
He is
has been,
absconding, that is all right, my lord. Absconding.
earlier order, my lord, I want to show, my lord. My learned friend has said, page 31, my lord.
Yeah.
There is nothing incriminating material because the investigation on earlier stage, my lord, initial stage, that is why my bail application has been rejected. It is not that, my lord, he also released on bail, my lord. There is a cross case between the party, my lord. And he also released on bail. And my lord, I also, my lord, in the accused, although nothing has been, I am going to the 161 statement, my lord. Not a single witness say anything, my lord. And earlier, when your lordship has rejected, my lord, other accused person are released on the absolute bail, my lord. But they are concealing the material fact that bail earlier your lordship has rejected, my lord. I am the only person who has disclosed all this thing before this honorable court, my lord. That, my lord, that bail annexer page 21, Warim Ali, FR has been filed. Lal Baru Ami, my lord, charge sheet filed. Norzurul Haq, FR filed. Abu Bakr Sheikh, my lord, charge sheet has been filed, but he was released on absolute bail, my lord. That order is available, my lord. But I am disclosing everything before your lordship, my lord. That Abu Bakr Sheikh है bill order to them Abu Bakr Sheikh. This is the order. Abu Bakr Sheikh is released on absolute bail, my lord. He was concealed the fact. Subsequently, he was penalized for 10,000, my lord, for concealing the fact. But his absolute bail was not disturbed, my lord. AB. कितने बोल रहे? Only 5,000 cost. I don't know.
What was the order for compliance?
My 5,000 cost has been given to them because they are concealing the fact. Subsequently, they have deposited the amount, my lord.
They have not declared the amount.
That is not related to me, my lord. My humble submission before your lordship. Anticipatory bail. Eh? Cancel.
No, are there any allegations that he is not complied with the condition? No, this is
Yes, this is very only last. Protection only.
Heard Mr. NND Tawari, Council. Mr. P.K. Parakor, Learned APP, appearing for the state, and Mr. F.A. Hassan, appearing for the informant. This anticipatory bail.
Only request Malak in case of pending on the speak. But
Yes, ma'am.
and Malak they have to regularly appear and not to treat Malak.
The anticipatory bail petition is filed by the petitioner seeking bail in connection with Orbo Police Station case number 31 of 2023 under section so and so, so and so. So, the apprehension of arrest expressed by the petitioner is pursuant to an affair lodged by the informant, alleging that the informant's brother were attacked, were sustained grievous injuries on an attack on being assaulted by a group of persons. And subsequent there, the father and the elder brother succumbed to the injuries sustained. So, the petitioner submits that he is no way connected with the case involved, and therefore his prayer for bail should be considered and he should be released on bail. So it is submitted that by order dated so and so, the court had been pleased to grant the interim bail to the petition, to the bail to the petition. So on several dates, the trial court reports have been requisitioned. Scanned copies of the trial court reports have been requisitioned. And it is seen that the matter is still at the stage of appearance because of the one of the accused being shown to be an absconder. So, the charge sheet in the matter was filed on 16/5/2020. Thereafter, the trial, thereafter the examination of witnesses not yet commenced. What is the name of the petitioner?
Lalbor Ali. But in the content of the charge sheet, 161 statement, not a single allegation against this petitioner.
After the scanned copies of the court have been placed before the court, and after careful perusal of the charge sheet, it is seen that there are specific allegations against certain other persons who are suspected to have inflicted the injuries on the victims and their relatives. So, when the charge sheet was initially filed, the petitioner was amongst some of the persons who have been shown to be absconders. So, pursuant to the interim bail granted by the court, the petitioner had appeared before the trial court and has been allowed to remain on interim bail. So, thereafter, only from the case records scanned, it is scanned case records available, it is seen that the petitioner has appeared on each and every date. Stop. The earlier order dated 27/4/2023 passed in the bail application, anticipatory bail application, dated number 7/21/2023, filed by the petitioner. Was rejected on the ground that the inquiry is still at the initial state and charge sheet was yet to be filed. So, presently, the inquiry has been completed and charge sheet has been filed. Although at the stage of filing the charge sheet, the petitioner has been shown to be an absconder. Subsequent to grant of interim bail, petitioner, you have appeared before the authorities? No. What about his statements?
My
Statements.
Hmm?
Charge sheet has already been filed.
Yes,
He is
sir.
shown to be an absconder.
Sir.
So there is no material against him
Yes, well,
as on date.
sir. Yes, appear before the court, no. Court, my lord,
You have
because,
appeared before the court in terms of the directions of this.
yes, my lord, yes, my lord. But your lordship has, I shall abide. But now the charge sheet has been filed, my lord.
So charge sheet has been filed, but you are shown to be an absconder.
Yes, my lord. I shall appear before the police, my lord, if necessary.
The earlier bail order
Yes, my lord.
was passed, your bail petition was rejected on the ground that there are serious allegations, material
Yes, my lord.
investigation is not complete.
Yes, my lord.
Now investigation is complete. Charge
Charge
sheet
sheet has been,
filed,
yes, my lord.
but there is no material against you because you are an absconder.
Only because of abscond.
No, my lord.
You have been
Subject-
shown to be an absconder.
So
how
my
does
humble
no-
submission before your lordship is that, my lord, there is a witness. Case shall be proved by the witnesses, my lord.
Right.
There are many witnesses. If your lordship go to the 161 statement of the, my lord, witnesses, not a single witness said anything against the petitioner, my lord. Now, under Article 20, subsection 3, no one can be compelled. This is not the part of the case. Compelled to give evidence against him, my lord. This is the law, my lord. Now, my lord, on the basis, case should be proved on the basis of evidence gathered from the, my lord, prosecution witnesses. Death has been completed, and that is why charge sheet has been filed. Police, my lord.
Right.
Yes,
but
my
you
lord.
remained an absconder at that point in time.
Yes, my lord. But if necessary, I shall appear before the police, my lord.
To what effect now?
Yes, my lord. Yes, my lord. Normally, case shall be proved from the witnesses, my lord. No.
It shall be proved from the witnesses, but in the course of investigation, you did not participate. You remained an absconder.
Oh, this is a part charge sheet, my lord.
Part charge in respect of those people
Yes, sir.
who have been against whom the investigation has been completed.
Yes, my lord.
Only, yes, and one is not there. Other witness exam, they have said that hospital who has killed and all this. Those are there.
But my lord, I am the accused in this case, my lord. I am not the witness. What the witness said, that is available in the, my lord, evidence, my lord.
What we wanted to see, but the case has not proceeded. Had some witnesses been examined,
Yes,
it
sir.
have been clear before us that what materials are there before you. But the case has not proceeded because of one person, failure of one person to appear. Now, what materials are available before this court?
Yes, ma'am.
They will accept the statements of the witnesses under 161.
Yes, my lord.
What materials are there? Your statement is also not there.
Because, my lord, my statement cannot be used against me, my lord.
May not be, but
Yes, my lord.
for satisfaction of the court.
Yes, my lord. Then I shall appear before the police, my lord. My statement may be recorded, my lord. Normally, what happened, my lord, when charge sheet has been filed, my lord, the case shall be proceeded on the basis of prosecution witness evidence
Exactly.
and other material available. That is available in the case record, my lord.
That is available, but the trial has not commenced. Against it.
Charge was not framed because one of the declaration absconder, my lord. That is, my lord. Anyway, my lord, in the charge sheet, my lord, except this line, he was declared absconder. Nothing material against this accused person, my lord. And 161 I have gone. Not a single witness said anything against him, my lord. It is a, my lord, group fight between the two parties, and I am the co-villagers, my lord.
So you are not the only person before
Yes,
the
my
court
lord.
coming for
Yes,
a
my
bail.
lord. Yes, my lord.
In
But
fact, the earlier order
Yes, ma'am.
reflects that the bail petition was filed by as many as 4 or 5 persons. Huh?
yes, my lord.
How many persons are before the court today?
They only one. Other 4% final report has been submitted. I submit, my lord.
There are total 6 persons.
Yes, my lord. Against 4 final report has been submitted.
Where is it?
That is in the charge sheet, my lord. Charge sheet.
Mr. Porahor, is it there?
এই প্ৰথমতে নামটো ক'ত আছে কেছ কিমান কৰিছে ইমানটো ক'লো যে yes my lord the name mentioned my lord Karim Ali final report has been submitted my lord as per as Lalbor Ali me my lord Nurul Haq final report has been submitted Abu Bakr Sheikh charge sheet submitted he is separate bail application filed he has released on absolute bail Nurul Islam Haq final report submitted and এইটো কি লিখিছে চশমা জব থলো
Moizel Haq.
Yes, my lord. Final report submitted. If you also go to the charge sheet, person person charge paragraph to law.
Yes, Mr. Parahor, please point out the relevant portion.
Page 81, my lord. 81. Karim Ali, Nurul Haq,
Page 81 is
Karim Ali.
not charge sheeted. This is with respect to persons not charge sheeted.
Not charge sheeted, no? Karim Ali not charge sheeted, page 81.
Okay.
First one, what to learn this? Then, my lord, this is the Nurul Haq.
He is charge sheeted.
He was bail application rejected. আর কি হয়েছে সামনে কি লেখা আছে নুরুল হক মোর লিস্টখান কি করলাম আমার তো যেতেছে
From where are you submitting? It's not there.
81 my lord
81 is only one person.
yes I am coming one by one my lord order তুলবো না then my lord লালবর নুরুল হক my lord নুরুল হক my lord your lordship will find page 82
Karim Ali.
82 this final report has been submitted no
Mr. Parahor,
Nurul Haq next my lord
Ghulam
Abu Bakr Sheikh Sarsidat T and Nurul Islam Haq Nurul Islam Haq my lord
Zakaria. Bakr Ali.
huh
My lord, from page 81 to 91 of the petition, those persons, my lord, page 81 shown as against whom charge sheet not filed.
Nurul Islam page 91 no Nurul
But-
Islam page 91
But petitioner's name is not there and petitioner's name is shown as absconder.
no, petitioner's name is not there.
Not there.
What,
earlier rejected
What?
final report has been submitted
where is the earlier order?
earlier the page 28
So there are 6 persons who had filed the bail application. Five person besides the petitioner in the
Yes.
earlier bail petition. So out of that, Karim Ali,
yes my lord
then
then my lord
Nurul Haq,
Nurul Haq
then
then Nurul Islam Haq my lord Moizul Haq
Nurul Islam Haq
and Moizul Haq
Moizul.
That's all.
What about the Abu
Bakr.
Bakr?
Bakr also.
He was solicited, my lord. He is a other bail application file concealing the fact. He was released on absolute bail, my lord.
Where is his order?
This order I have already given. Asli karo tada. Honorable Middle Court judge, no? Honorable Justice. Honorable Justice. MK Koli. This is the certificate copy of the. No, it's not. He did that. I think Abu Bakr is a bail sale. No, it's Middle Court judge. Dilu about. I have already given, I think, given to your
That you take down by the earlier order dated 27/4/2023. The bail petition filed by the behalf of the petitioner and 5 other persons came to be rejected. The ground that the investigation was at the initial stage and charge sheet is not filed. And the allegations against the petitioner are grave punishment prescribed as during the course of the hearing, the counsel to the petitioner has written charge sheet file. Submit that charge sheets have not been filed against the one against Karimati, Nurul Haq, one Nurul Islam Haq, and GL Haq. So these persons were petitioners along with the present petitioner in the earlier bail application, being the AB number 721 of 2020. Insofar as Abu Bakr Sheikh is concerned, this person was charged sheeted and subsequently he's been released on bail by a coordinate bench
Yes, ma'am.
by the order dated so and so passed in AP petition. It was that order. It was the order of Abu Bakr Sheikh.
That has been given, I think. This is
No,
the
don't know. Give us an extra copy.
the name of the new one.
It's counted with something that the entry bail branches he made it and he'll abide by the prescribed.
Yeah, man, that's it.
Yeah.
I'm not sure how that.
On hearing the counsel to the parties, what is your objection?
This is the second time bail application. Earlier one time rejected after perigil of the territory, my lord. So, my lord, they will kill our 2%, my lord.
The counsel for the complainant
No,
submits that the bail petition prepared should be rejected, and this is the second bail application, and the earlier bail application was rejected. Perigil of the case diary, and
It's 100%.
incriminating material having been found against the petition. Correct. The learned APP, the other end,
No,
submits that
no, I was with
does not dispute the contention of the counsel to the petition that the person mentioned in the earlier bail application being AP petition number 721. Except the present petitioner and Abu Bakr Sheikh, where persons against whom no charge sheet has been laid. So, insofar as Abu Bakr Sheikh is concerned, counsel learned APP fairly submit that he is already released on bail and his bail is made absolute by order dated so and so passed by court in time. So far as the petitioner is concerned, it is submitted that he was shown to be an absconder at the time when the investigation was undertaken. And accordingly, charge sheet was filed showing the respondent as showing the petitioner as an absconder. He, however, submits that pursuant to the interim bail granted, petitioner has appeared regularly before the trial court. So, he also submits that the examination of witnesses have not been finished. And the matter is still at the stage of appearance. Counsel for the parties have been heard, meeting the relevant report. The scan copy of the case report is all board have also been approved. It is seen that by the earlier order dated 27/4/2023, the earlier bail petition was rejected as the investigations were underway and charge sheet has not yet been filed. And that the allegations were grave. Allegations made against the petitioner were grave. So, pursuant to the rejection of the earlier bail petition, the charge sheet has been filed, showing the petitioner as an absconder. So, by order dated 3/8/2023, the petitioner was allowed to go on interim bail on furnishing a bail bond of 30,000. And subject to the condition, subject to the adherence of the conditions specified in the same order.
Similarly.
Petitioner was at large not getting bail. And from the report, it is that will appear before the trial court of each and every case. Verdict of fact that the petitioner has appeared before the trial court and also taking into consideration the fact that except Abu Bakr Sheikh and the present petitioner were filed the earlier date being paid 7/21 were not named in the charge sheet. So, so far as Abu Bakr Sheikh is concerned, by order dated 9/9/2024, passed in BA 2590/2024. He was enlarged on bail. So, under such circumstances, keeping in view the submissions made by the council, and in order to maintain parity, the interim bail granted petitioner be made absolute of the same term and condition. Petitioner will continue to appear before the trial court on each and every date. Any violation of the conditions mentioned will permit, will uh, uh, give liberty to the prosecution to file necessary application before this court for cancellation or modification of the bail order granted. If the petition according to stands allowed in this court of the yes.
Lordship, this matter can otherwise be taken up for disposal, Your Lord. This matter can be taken up for disposal. They have filed their affidavit. It's a very short point. What had happened, the petitioner had participated in a tender process, Your Lordship, for procurement of desks and benches by the BDC. After submission of his bid, they issued a corrigendum extending the date of bid submission, then changed the eligibility criteria in the tender. So if I may,
Your bid was rejected.
my bid was not rejected.
Yeah.
I participated in the tender process. After my participation, they first extended the date of bid submission. Then the eligibility criteria, which was in the tender, that was changed. Now it is going to be rejected because I am not eligible. But after I have participated in the tender process, on the basis of some eligibility criteria which have been announced, can they then unilaterally change the criteria or not?
Not after, my lord. It was changed during it, but he knew it that it had been changed, my lord. Then immediately going it that it has been changed, he filed.
We'll take it up for admission hearing in the month of May.
No, my lord. Lordship will put it on of this reopening date. Urgency is the decks and benches for the student, my lord.
There is an interim order.
There is an interim order, that's right, my lord. Lordship will fix it on 22nd, my lord. April
Out of 22nd, we'll have it on 29th.
29, my lord.
29th. It's from 29th. As it is submitted, the pleading.
The interim order has to be continued.
Interim order passed early will continue.
Deeply.
I'm sorry, my lord. I'm extremely sorry, my lord. I could not
reach in time, my lord, and find the item 65 is, my lord.
Item number?
Item number 65. That is a contempt matter, my lord. My lord. I was in port number 22, my lord. I am sorry, my lord. That on the last occasion, my lord, two occasions, my lord, counsel for the respondent were
You were
not present.
supposed to verify something.
My lord, I have verified, my lord, this person is still in the share, my lord.
Which person?
And that is, my lord, managing director of Assam Fishery Development Corporation, my lord.
Service is complete.
Service complete, my lord. Mr. P. Sharma appeared. On last two occasions, he did not appear, my lord.
His name is reflected here.
My lord.
His name is reflected in the court list. Item number?
Item number 65, my lord, orders item number. Last item.
Name is reflected. Right, we'll take it up on Friday.
My lord. My lord.
Or on Monday, after reopening.
My lord.
It will be listed immediately after reopening, showing the names of the council appearing.